The treaty's ban on terrorism financing covers assets of every kind, including a Buk anti-aircraft system, multiple launch rocket systems, limpet mines. The ordinary meaning of assets of every kind, tangible or intangible, is weapons, equipment, other forms of property, as much as the rubles or dollars used to buy such weapons, equipment, and property. All of these are tangible assets, assets of every kind, and therefore funds of the kind Russian officials may not supply if they are serious about seeking to suppress the financing of terrorism. In Russia's rejoinder, it grudgingly concedes that the term assets may convey the meaning of the property of a person in the broad sense as indicated by Ukraine. So the parties agree on the key point. The ordinary meaning of assets, and here funds, covers every form of property, including weapons. But Russia tries to escape the ordinary meaning of assets by narrowing it to conform to their own dictionary's definition of funds. This is backwards treaty interpretation, a task for which dictionary definitions are simply beside the point. Recall Article 31(4) of the Vienna Convention on the Law of Treaties. A special meaning shall be given to a term if it is established that the parties so intended. Article 1 of the ICSFT included a set of definitions for the purposes of this convention, including, as we saw, the treaty's own special meaning or definition of funds as covering assets of every kind. The special meaning of funds is assets of every kind, not some definition found in whatever dictionary Russia's lawyers might find. To impose generic dictionary definitions on interpretations of particular treaties, which choose their terms carefully, would upend treaty making by denying drafters the option of adopting specialized definitions that are tailored to meet the particular purposes of a particular treaty. Equally backward is Russia's reliance on the word financing in the treaty's name. That term is prominently nowhere found in the treaty's text. Treaty titles are not operative provisions. By using only the word funds, the text gives that term special meaning, assets of every kind, which defines the breadth and forms of financing the treaty is designed to suppress. Madam President, members of the court, many nations use the term financing of terrorism as shorthand to cover the many variegated forms of terrorism support. For just one example, look at the Russian Supreme Court. Its own reading, the financing of terrorism along with the rendering of financial services, should be understood as a provision or collection not only of money, cash or non-cash, but also material assets, for example, items of uniforms, equipment, means of communication, medicines, residential or non-residential premises, vehicles. So Russia's artificial attempt to narrow the interpretation of funds to monetary assets would offend its own national law as construed by its own Supreme Court. Yet Russia repeats the same flawed tactic that it tried and this court rejected earlier in these proceedings. Russia tried to convince this court that the term any person in Article 2 must mean some persons. This court correctly decided any means any. Similarly, in Article 1, the term every means every. When the treaty refers to assets of every kind, it cannot mean, as Russia argues, only assets of some kind, the monetary kind. Russia's interpretation also violates this court's directive that treaty clauses must be interpreted to avoid rendering them superfluous. The treaty's clarification that an asset may be movable or immovable only makes sense when the term is given its ordinary meaning, assets of every kind, meaning property. Because the treaty prohibits providing an immovable asset like a warehouse to a terrorist to be used as a hideout or weapons depot. But if, as Russia claims, assets of every kind were limited to money, to what then would the term immovable assets refer? Money moves, there's no such thing as immovable money, Russia's reading of funds as monetary assets would make the treaty's mention of movable or immovable assets superfluous. Russia also misreads the second part of the treaty definition of funds. After defining that term to include assets of every kind, it adds, and legal documents or instruments in any form evidencing title to or interest in such assets, listing examples of such documents or instruments. Russia incorrectly calls this list the exclusive and specific categories of assets covered by the ICSFT, claiming that nothing else is covered. Plainly, this is wrong. The definition does not exhaustively describe whatever constitutes assets. It only lists documents or instruments that evidence title to such assets. But on its face, the convention bars providing terrorists of assets of every kind, not just those assets for which someone can prove title by producing a piece of paper. So once again, Russia asks you to ignore the plain terms of the treaty to shrink its scope. Most obviously, Russia's interpretation defies the broad object and purpose of the ICSFT, whose obvious goal was to deny groups any and all resources necessary to commit terrorist acts. Money on its own cannot be used to commit terrorist acts. The international community wanted to prevent terrorists from receiving money because that money can be exchanged for goods that can be used to commit terrorist acts, such as explosives, arms, and equipment. What sense would it make to forbid providing money to terrorists, but allowing the same terrorists to receive directly goods, weapons, and arms that the same money would buy? To accept Russia's attempt to carve this gaping loophole into the treaty would gut the treaty and render it meaningless. And finally, Madam President, the travaux preparatoires confirm assets of every kind mean just what it says, all forms of property, including weapons. From the beginning, the treaty's drafters focused not just on financial and monetary assets, but weapons as well. This early draft of the convention defined the act prohibited by Article 2 as, quote, financing. The substantive offense of financing encompassed financial and non-financial assets. And draft Article 1 defined financing broadly to include not just funds, but assets or other property. At the time, the term funds was defined narrowly to cover any type of financial resource, including cash or currency of any state. But non-financial assets were covered by the term assets or other property. The negotiators debated this wording. No one suggested shrinking the scope of the treaty to address only financial resources. No one ever proposed dropping all non-financial assets from the treaty. Instead, the debate concerned whether to cover just financial resources and weapons or financial resources, weapons, and other forms of property. And as this summary of the negotiations explained, suggestions were made to delete the phrase or other property is superfluous. Some argued in favor of deletion of the word assets. Others preferred retaining both assets. Some preferred interpreting property as covering only arms, explosives, and similar goods. So, as this reflects, there was a proposal to narrow the type of non-financial assets covered. But none of the proposals would have eliminated weapons from the coverage of the treaty. Given this history, Russia's rejoinder is wildly misleading when it claims that the issues of weapons was, in their words, quote, not discussed at all when the convention was negotiated. What this excerpt shows is that weapons, arms, and explosives were openly discussed when the convention was negotiated, and everyone agreed that the convention barred the provision of weapons to terrorists. Ultimately, the states parties resolved the wording debate by taking the concept of financing out of the text and replacing it with a broader definition of funds, defined as assets of every kind. The drafters gave the term funds the broader special meaning given to the definition of property in the Narcotics Convention, assets of every kind. This outcome thus made any separate reference to property, quote, redundant, since it was already envisaged in the concept of funds as defined in Article 1. The drafters adopted a proposal that the term property be deleted wherever it appears in conjunction with funds, since funds was now intended to refer to all property. In short, the travaux clarified that the final version of the treaty omitted the word property because the umbrella term was now funds, assets of every kind, which plainly includes non-financial forms of property, including weapons. This consensus was confirmed after the convention was finalized during the ratification processes in many countries. In the United States, a senior senator asked, in Article 1, does the term funds include non-financial assets such as personal or real property? That senator was named Joe Biden. The State Department responded, yes. All delegations understood the definition to include property. So leading commentators as participated in the negotiations confirmed this view. Marja Leto, who led Finland's delegation, explained that the expansive definition of funds covers material assistance. Roberto Laval, a Guatemalan diplomat who served on the Sixth Committee, agreed. The deliberately wide definition swept in such, quote, material assistance as the direct provision of weapons. So in the end, every tool of treaty interpretation points to the same result. By its terms, the Convention encompasses assets of every kind. Weapons are one kind of asset. The treaty drafters well understood and discussed that the Convention covers all forms of property, not just financial assets. And after the treaty was finalized, states and commentators universally reaffirmed this breadth of coverage. Yet against this evidence, Russia asks you to read an absurd exclusion. They would have you rewrite the phrase assets of every kind to mean assets of every kind except dangerous weapons. This outrageous misreading would create a gigantic loophole through which recalcitrant states could entirely flout their legal duties. While state officials looked the other way and did nothing, private parties could send weapons to Al-Qaeda. A treaty partner could pretend to be suppressing the financing of terrorism, even while allowing or assisting supporters of terrorism to deliver unlawfully the very lethal weapons used to carry out terrorist acts. And this is exactly what Russia is doing here. Russian officials and private supporters are delivering lethal bombs, shells, and missiles directly to those terrorizing the civilian population of a peaceful neighboring country and pretending that they are obeying this convention. Madam President, members of the court, this is not a good faith interpretation of the treaty. It cannot be the law. This misreading violates the convention's ordinary meaning and object and purpose. It's a brazen attempt to escape the solemn commitments Russia made when it ratified the treaty 21 years ago. It would justify Russia's continuing refusal to cooperate with Ukraine in suppressing the financing of terrorism. And adopting their reading would reward and reinforce Russia in its naked contempt for the rule of law and human rights of Ukrainian citizens, which we are all witnessing every day. Madam President, that concludes my presentation. I now ask you to call Professor Tuvinen to the podium.
I thank Professor Coe, and I now give the floor to Professor Jean-Marc Tuvinen. You have the floor, Professor.
Merci, Madame la
Thank you, Madam President. Madam President, distinguished members of the Court, it's always a tremendous honour to speak before you, and today thinking particularly of the judges who have departed and before whom I had the pleasure of pleading in the past. The applicant has entrusted me with the task of shedding light for you on the scope of Article 2, Paragraph 1 of the International Convention on the Suppression of the Financing of Terrorism. I'd like to begin by showing the text on the screen. For your comfort, you will also find it in tab 2 of your file. I'll not read it out. Ukraine contends and demonstrates that persons did commit unlawful acts within the meaning of the chapeau of Article 2, Paragraph 1. In other words, offences financing the acts that come under subparagraphs A and B of that same paragraph. However, the matter before you is not the criminal accusation of a person or a legal entity. You have before you a dispute between Ukraine and Russia because of the total, I would even say culpable, passivity of Russia in the face of massive flows of financing for terrorist acts, coming not just from its own territory, but also from its own state officials. This is the case that Ukraine is making before you. For its defense, Russia puts to you a totally erroneous interpretation of Article 2 of the Convention before persisting in distorting facts. Maître David Zients will, after me, give you the interpretation of Article 2, Paragraph 1, subparagraph A. I shall deal with the remainder of Article 2, Paragraph 1, and to begin with, I will refer to subparagraph B, and then, after that, go to the heading of Article 2, Paragraph 1. I shall conclude by recalling the terrorist acts committed by the armed gangs of Donetsk and Luhansk in the spring and in the summer of 2014. So let us begin with Article 2, Paragraph 1, subparagraph B. It refers to all acts that are not already covered by subparagraph A if they show two cumulative features. First of all, any act intended to cause death or serious bodily injury to a civilian or to any other person not taking an active part in the hostilities in a situation of armed conflict. Secondly, the same acts are covered if, when the purpose of such act by nature or context is to intimidate a population or to compel a government or an international organization to do or to abstain from doing any act. Russia claims that an act fits in with this description if and only if it is proved that there is a twofold intention on the part of the perpetrator, intention to cause death or bodily injury to civilians, and the intention to do so with the sole or main purpose of intimidating a population or compelling a government. Ukraine, a contrario, contends that it is enough for the acts to be of a certain nature or to be committed in a certain context to fall under subparagraph B without there being any need to prove in any other way the subjective intention of the perpetrator of those acts. Therein lies our dispute. Madam President, the Court can already note that the parties agree that the first feature of the act described in subparagraph B, which is intended to cause death or serious bodily injury to civilians, is present when a person or a group of persons carries out a lethal action deliberately targeting civilians, including in a situation of armed conflict. Ukraine has demonstrated and will demonstrate again today that the terrorist actions to which it was subjected are precisely murderous deeds that deliberately targeted civilians. But Ukraine also contends that in order to determine what is an act designed to cause death or serious bodily injury of a civilian within the meaning of subparagraph B, the subjective intention of the author, the perpetrator, does not need to be established. Subparagraph B is purely descriptive. It gives you a category of facts. The only perpetrator targeted by Article 2 under the offence that is established is the person providing the funding. It is that person committing the offence created by the Convention, not the person perpetrating the acts financed by the funding. So the act intended to cause death or injury is described objectively by the fact that by its nature, and not because a perpetrator entertains certain ideas. The result is simply to cause death or serious bodily injury to civilians. The defendant provokes another line that's already rebutted at length in Ukraine's written submissions. So with all due respect, I would suggest to the court that you read paragraphs 155 to 161 of the reply, and I shall remain concise on this point. On the one hand, Russia confuses the acts committed with the intent to, mentioned, for instance, in Article 2, paragraph 1, subparagraphs A and B of the Convention for the Suppression of Terrorist Bombing, or again in Article 2 of the Convention on Genocide, or again in the chapeau of Article 2, paragraph 1 of the CERD Convention. You can see the text on the screen, and they expressly refer to the intention of a perpetrator of an act. And what is more, the acts intended to, which are covered by subparagraph B, that is the subject of my presentation here. There should be no confusion here. These are two formulations that are intentionally separate. The first refers to a perpetrator's intention to carry out a criminalized act, and the second describes objectively an act with regard to its destination, in other words, as regards the end result, without necessarily criminalizing it, in other words, without taking a look at the criminal intent of its perpetrator. Russia incorrectly is reasoning as if the convention were criminalizing the acts intended to cause death or bodily injury to civilians that it prescribes the financing of. This is not the case. So it is wrong to interpret from the angle of criminal law, subparagraph B, requiring that the intent of the perpetrator of the acts described be established. Furthermore, Madam President, as regards Russia, at least as it stands here before you, because back home its interpretation is quite different, the Italian Court of Cassation does not commit the error that Russia would have you make. It does not take account of the intention of the perpetrator of the act covered by subparagraph B, but only the nature of that act. In Italy versus Abdelaziz et al. From 2007, its ruling was crystal clear, and I quote,
"Against a military objective must also be regarded as terrorism if the particular circumstances show beyond any doubt that serious harm to the life and integrity of the civilian population are inevitable, creating fear and panic among the local people." A simple example is an attack using explosives against a military vehicle in a crowded market.
End of citation. Your court will also note the ruling of the Supreme Court of Denmark from 2009 in the case Fighters and Lovers, where it was a question of interpreting the Danish law on implementation of Article 2, Paragraph 1, subparagraph B of the Convention. The Supreme Court ruled that the FARC, the Colombian Revolutionary Armed Forces, that had received funding for which those providing it were prosecuted, were deemed to have committed acts referred to under Article 2, Paragraph 1, subparagraph B, inter alia, because they had used inaccurate mortar shells in civilian areas where civilians died from their injuries. It did not seek in any other way the subjective intention of those who had fired the shells. Madam President, distinguished members of the Court, there is a second feature that an act must have in order to be covered by subparagraph B. Its purpose must be to intimidate a population or to compel a government or international organization to do or abstain from doing an act. How do we know that an act has such a purpose? The text tells us. It is by taking account of its nature or its context. That does not mean that the purpose of the act is not a relevant element. It is. The court furthermore suggested this in its decision on provisional measures, and in this respect, the lengthy developments by Russia under paragraphs 236 et sec of its counter-memorial state the obvious, if you don't mind my saying. But this means that, as regards subparagraph B, determination of what is the purpose of an act is done in the light of the nature of the act or the context in which the act is committed. That is precisely what the text of Article 2, Paragraph 1, subparagraph B says. The words are carefully chosen. No reference is made to the intentions of the perpetrators, and let me recall once again that they are not criminalized by the Convention, contrary to the Convention on Genocide, to which Russia vainly clings, and contrary to other texts, such as the chapeau of Article 2, Paragraph 1 of the Convention of the CERD. What is more, whether I need to verify this in the light of travaux préparatoires, we'd see that the drafters of the Convention have expressly, intentionally excluded this intention. During the discussions within the working group of the 6th Committee of the General Assembly, Costa Rica and Mexico proposed that subparagraph B be rewritten in the following fashion. I quote, acts intended to cause death or serious bodily harm to a person when such acts are committed with the intent to provoke terror in the population or to compel a legal person, an international organization, or a state to commit or refrain from committing an act. End of quotation. This amendment, which was on its own, did not succeed. The chair of the working group of the 6th Committee gave an explanation for this in its report, and I quote once again, a proposal was made to delete the phrase by its nature or context. Some opposed this deletion because it would suggest that the offence required proof of the perpetrator's subjective state of mind. End of quotation. So it was dismissed. The Russian argument is thus unsupported. But, Madam President, distinguished members of the Court, Russia also persists in arguing that the purpose of the act, described in subparagraph B, must be solely or mainly or specifically to intimidate the population or to compel a government. Or it quite simply says intimidate the population. There are 3 answers to be given here. Each is critical. First of all, and it is really quite striking, Russia claims that the interpretation of Article 2, Paragraph 1, Paragraph B, and let me remind you here that it concerns not just the acts whose purpose is to terrorize the civilian population, but also those which serve to compel the government, in the light of other texts, inter alia additional protocols 1 and 2, which under terrorism state that its acts, the purpose of which is to strike terror in the civilian population, excluding any act whose purpose is to compel the government. The scope, the substance of the texts is manifestly very different. So interpreting the first in the light of the others would be totally disjointed. Secondly, for the Russian argument to prevail, it would be necessary to rewrite the text because the latter does not say when the purpose of such an act, by its nature or context, is to intimidate a population or compel a government. contrary, for example, to Article 13, paragraph 2 of the Additional Protocol 2, or again, paragraph 84 of the rules concerning application of international humanitarian law by the armed forces of the Russian Federation, which was published on the 8th of August 2001 by the Russian Ministry of Defense, which forbids acts of violence whose main purpose is to strike terror into the civilian population. But Russia cannot rewrite the text. In the convention discussed here, the notion of main purpose is not to be found, neither explicitly nor implicitly. Thirdly, Russia would once again have you forget that the sole purpose of the convention is to prevent and suppress the financing of terrorism. It would have no effet utile in terms of preventing the financing of terrorism if it were necessary before a state can demand that another state cooperates in order to bring an end to the financing of acts that cause death and injury to civilians and whose purpose is to terrorize the population or to compel a government to prove that that purpose is main or sole. Whatever Russia says, Madam President, distinguished members of the Court, within the meaning of the Convention, an attack that deliberately targets an area known to be full of civilians, or an indiscriminate attack, inter alia using inaccurate weaponry with no capacity of discernment, fired over an area in which there are civilians and military personnel, is an act whose purpose, by its nature or context, is to terrorize the population, independent of the fact that there might be other targets, for instance, military ones. Let me add that such acts also have the purpose, by their nature or context, of compelling the government. But Russia, never short of subterfuge, claims in its counter-memorial that the Convention would not apply in a situation of armed conflict when the purpose of the financed acts is to compel the government. It claims that this is because the law on armed conflict does not qualify as terrorist acts whose purpose is to compel the government, and that the Convention should be interpreted in accordance with the law on armed conflict. Consequently, according to Russia, in a situation of armed conflict, any compelling of the government would be covered by subparagraph B only if, and I quote Russia, if it is related to something beyond the overall goal of armed conflict as such. End of quotation. Something beyond? The Court will lend no credibility to this argument that's been pulled out of thin air. Madam President, because of these latter comments, I will have to go further into the role that Russia would have the law on armed conflict play. Article 2, paragraph 1, subgraph B. Its argument is that that cannot qualify as an offence an act which, what is more, was not considered as terrorist by international humanitarian law. In other words, what is, according to Russia, lawful in humanitarian international law cannot be unlawful under the Convention on Financing of Terrorism. The Court will doubtless note that this is a purely academic debate because none of the acts whose financing has been incriminated by Ukraine is compatible with humanitarian international law. Nevertheless, the Russian argument is legally flawed. First, international humanitarian law authorizes nothing of any relevance here. It only proscribes. This does not mean that what is not forbidden under international humanitarian law is deemed authorized by international law. On the contrary, what is neither proscribed nor permitted under international humanitarian law may still be proscribed by other branches of international law. Secondly, contrary to international humanitarian law and contrary to Russia's sustained belief, the Convention is not intended to create terrorism offences, neither in times of armed conflict nor in times of peace. I have already made the point. It is neither its purpose nor what it does. It simply criminalizes transnational financing of certain acts that it describes. In contrast, the law on armed conflict is not concerned with the transnational financing of terrorism. So there is no reason to limit arbitrarily the scope of the Convention by referring to international humanitarian law, which cannot be the lex specialis, because by definition there can be no normative conflict between the two sets of standards. Moreover, if one were to invoke the notion of lex specialis, quod non, this would clearly lie with the Convention, because it alone deals with the financing of certain acts. What is more, without any doubt, the Convention is lex posterior.
Madam President, distinguished members of the Court, I mentioned that what is considered as an offence by the Convention is the funding of certain acts. Allow me now to address the chapeau of Article 2, Paragraph 1. Ukraine contends that it follows from this text that an offence is established when the financier provides funds to a group known to commit acts for which funding is prohibited. So, a well-known terrorist group can use funds made available in different ways, for example, for propaganda campaigns or to buy food supplies, military uniforms, transport vehicles, or even weapons. But monetary funds are fungible. I will talk about weapons in a moment. Therefore, the person providing such funds to a group known to carry out acts whose financing is proscribed is necessarily aware, due to their fungibility, and unless the use of such funds requires that proof of specific purchases be provided, knows that the monetary funds provided will be used or are to be used in full or in part in order to carry out acts for which providing funding is prohibited. Even so, the text states that the funds are to be used in full or in part, confirm that it is not required to demonstrate the precise attribution of those funds to specific acts under paragraph B. In fact, terrorists will probably never disclose their plans in advance. So if the financier were to be required to know beforehand what precise actions the terrorist groups intend to carry out in order to characterize the funding as an offense, it would probably never be constituted. Article 2 of paragraph 3 reinforces this interpretation because it establishes that, and I quote, for an act to constitute an offence set forth in paragraph 1, it shall not be necessary that the funds were actually used to carry out an offence referred to in paragraph 1, paragraphs A or B. End of quote. Furthermore, to demand a verification of the exact use of funds provided, which in practice is generally impossible, would be incompatible with the object and purpose of the Convention, which is to promote interstate cooperation to eliminate financing of transnational terrorism. It would be tantamount to interpreting Article 2, Paragraph 1 in such a way that it would make it meaningless, which would be contrary to the principle of meaningful formulated by the Court. And it is perfectly obvious that when the items provided to the group are weapons, the knowledge of the financier as to the utilization, their utilization, that is to say, to commit acts for which funding is prohibited, shall be established if the group is known to commit such acts. And, in fact, the best-informed commentators, some of whom were directly involved in the Convention negotiations, confirm this interpretation of Ukraine. The ambassador Maria Leto wrote,
has notoriously committed terrorist act would meet the requirements of paragraph 1. Fin de citation.
End of quote. She recounts that during the negotiations, it had been recurrently mentioned that violation of Article 2, Paragraph 1 is constituted in the case of
an organization that carries out multiple activities of a political and social as well as military nature, and where it may not be possible for the financier to make a distinction between the different possible end uses. Fin de citation.
End of quote. Along the same lines, Roberto Laval explains in his study on the Convention that I quote,
of a primary offense under the Convention, it is sufficient to prove that the recipient or recipients, actual or intended, of the funds are terrorists, that that person was aware of this, and that accordingly he or she had to know that the funds would probably be used or could be used to commit an offense or offenses covered by one of the treaties listed in the annex to the Financing Convention or falling within the residual category.
End of quote. To be thorough, Madam President, I would like to point out that Russia continues to hold on to the argument according to which it is not enough that funds were provided to a terrorist group by a person who did not know the details of how they would be used or only knew that there was a risk that the funds would be attributed to a certain kind of utilization. But Ukraine does not claim that ignorance as to the destination of the funds or the mere awareness of a probability that they will be used in a certain manner is the relevant criterion. Ukraine is of the opinion that Article 2, Paragraph 1 requires knowledge of the destination of the funds, but asserts that this knowledge can be deduced from objective factual circumstances and not simply by carrying out a detailed analysis of the subjective intent of the financier. In other words, if the financier knows that the beneficiary commits terrorist attacks, the knowledge criterion is met. Even so, Russia's quarrel with Ukraine on this point is not applicable because it acknowledges that financing a group known to commit terrorist attacks is an offense. Indeed, in its counter-memorial on the screen, Russia wrote the following in this regard.
It would be no defense for the financier to say that he/she intended the funds to contribute to the non-terrorist activities of the relevant group, or that he/she could not know whether the funds are to be used to commit a terrorist act or for some other purposes. Fin de citation.
End of quote. Russia appears to regret having had the honesty to concede this in its rejoinder. It now claims that only groups specifically identified as terrorists by the United Nations Security Council could be considered as groups known to commit acts described in subparagraphs A and B of Article 2, Paragraph 1. But obviously, knowledge that a person can have that a group is committing the acts described in subparagraphs A and B is independent of its identification by the Security Council, which is probably not the only source of information in this respect. The question is not, therefore, whether the Security Council has included armed groups of Donetsk and Luhansk in their list of terrorist groups. The question is whether the people financing them could have possibly been unaware. Therefore, they must have known, based on objective factual circumstances, that these groups committed acts covered by Article 2, subparagraphs A and B. This was clearly the case of the self-proclaimed Popular Republic of Donetsk and Luhansk in the spring and summer of 2014. Madam President, I have 10 minutes left. I leave it to you to decide whether you wish to take a break at this point.
Go ahead and finish up, and then we'll take a break after that. Please go ahead.
Merci, Madame la Présidente.
Thank you, Madam President. The acts of intimidation and terror committed by armed groups from Donetsk and Luhansk are documented. It was public knowledge. In spring and summer of 2014, nobody could have possibly claimed not to know their nature or context. In its successive reports in 2014, the United Nations High Commissioner for Human Rights underlined that numerous acts aimed at killing and seriously injuring civilians were regularly committed in the east of Ukraine. In its report of the 15th of November 2014, it says,
an increasing number of human rights abuses, such as abductions, harassment, and lawful detentions, in particular of journalists. This is leading to a breakdown in law and order and a climate of intimidation and harassment.
End of quote. The same report emphasizes
groups have increasingly committed human rights abuses, including abductions, torture, ill treatment, unlawful detentions and killings.
End of quote. In a report of June 2014, the High Commission for Human Rights was shocked at
acts of ill treatment and torture and killings by armed groups are now affecting the broader population of the two eastern regions, which are now marked by an atmosphere of intimidation and consequent fear.
End of quote. In another report dated July 2014, the High Commissioner deplored the fact that separatist groups of the Donbass, and I quote,
of Ukrainian territory and inflicted on the population a reign of intimidation and terror to maintain their position of control.
End of quote. In its report of 19th of September 2014, the Human Rights Council and the UN High Commissioner for HR observed, and I will say it in French, quote, the reign of fear and intimidation by the armed groups has been well documented in the reports of the Human Rights Monitoring Mission in Ukraine, end of quote. Russia did not contest these facts in its counter-memorial. And if more proof were required, all we need to do is recall how appalled the High Commissioner of Human Rights, Navi Pillai, was in July 2014. In fact, he is now an ad hoc judge in a pending case before this court. In October 2014, Ivan Simonovich, Deputy UN Secretary General for Human Rights, indicated the Security Council that the situation in the Donbass...
fear and terror in areas under control of the armed groups.
End of quote. There is no doubt that the aim of creating a state of terror by the so-called DPR and LPR was to force Ukrainians to accept that they had taken total control over Donbass. Apart from shelling and civilian areas, targeted attacks were perpetrated on specific individuals, which was very worrying for Ukrainians who were considered by the separatists as being pro-Ukrainian or pro-Maidan. They could be politicians, journalists, activists, or persons suspected of supporting Ukrainian authorities. In its memorial, the court will find, amongst other things, accounts of the terrible assassination of Mr. Rybak, municipal councillor of Horlivka, who dared to wave the Ukrainian flag on the town hall of his city on the 17th of April 2014, and assassination attacks of political leaders, the murder of a priest, multiple abductions and acts of torture. In other words, systematic persecution of opponents or persons considered as such. Russia pretends, or rather pretends not to believe, that such atrocities were committed with the aim of terrorizing the population or to compel the Ukrainian government. The counter-memorial also states a very strange theory, according to which, even though the Ukrainian population was terrorized by repeated violence by armed groups, it did not necessarily imply that these acts were aimed, due to their nature or context, at spreading terror. In fact, it was done inadvertently. The court will decide if this was the case. So what the Deputy Secretary General for Political Affairs, Mr. Feldman, denounced in front of the Security Council on 29th of April 2014 was, as I say, increasing reports of torture, kidnapping and violent acts and clashes were merely indiscriminate or senseless acts of violence or even heinous crimes? Is Russia claiming that the separatists suffered from dementia? Well, as soon as this claim is made, it collapses under the weight of its sheer inanity. In its rejoinder, Russia believes that it can convince us of the contrary by relying mainly on two cases. First, Russia attacks the murder of the municipal councillor of Volnovakha, Vladimir Rybak, that had horrified even the members of the Security Council during its meeting of the 29th of April 2014. Russia claims that it has not been established that this was a political assassination and that the DPR was involved. But as I noted in my introduction, we're not conducting criminal proceedings here against the perpetrators. What matters is that this act was denounced by UN organs and public reports as a political crime committed by separatist rebels. It is therefore a known fact. Russia then goes on to attack the murders of Valery Salo and other pro-Ukrainian farmers. It alleges that there was no proof of these murders because the Human Rights Commission published the facts that were reported to it without actually verifying their veracity, and therefore nothing can prove that this was not just a heinous crime or a personal vendetta. I will simply note that in its report of 15th of June 2014, the High Commissioner for Human Rights mentions in the first paragraph itself
findings of the United Nations Human Rights Monitoring Mission in Ukraine covering the period 7 May, 7 June 2014.
Amongst these findings, Mr. Salo's murder was mentioned because he was a pro-Maidan activist. This court sets great store by what UN organs write, and you will note that when the Human Rights Commission has a doubt in a fact, he indicates that it is alleged, which is not the case here. Whatever be the case, once again, the only real question here is to establish whether this incident reported by the High Commissioner of the United Nations and also by numerous media outlets makes it a known fact that separatist groups of the Donbass commit acts that, due to their nature and context, aimed at spreading terror in the population and compelling the government. The answer is, without the slightest doubt, in the affirmative. This brings me to conclude that, Madam President, distinguished members of the Court, in the spring and summer of 2014, no one could possibly ignore what the Ukrainian population was going through. DPR and LPR armed groups were known to be the perpetrators of numerous increasingly violent acts, falling manifestly under Article 2, paragraphs A or B of the Convention. In particular, acts aimed at killing or seriously injuring civilians. Their purpose, as observed by UN organs, was to take total or partial control over Ukrainian territory by dissuading through terror, by dissuading the population from resisting, and we know how much this population can resist. And this is why there were an increasing number of acts aimed at terrorizing them and to compel the government. It was public knowledge. No one could possibly ignore their acts of intimidation and political terror, and nobody providing funds to these groups could have ignored that they were going to be used for such acts. Madam President, this concludes my presentation in a hurry to take a break. And after the break, I urge you to call upon Mr. David Swans for his pleading. Thank you.
Mr. Tuvunen, before I invite the next speaker to take the floor, the Court will observe a coffee break of 15 minutes. Sitting is suspended.
These treaties include the Montreal Convention for the Suppression of Unlawful Acts against the Safety of Civil Aviation and the International Convention for the Suppression of Terrorist Bombings. As I will explain, the reign of terror that began in the spring of 2014 deepened in the summer and fall to include attacks on civil aviation and bombings across Ukraine. On the 16th of July, 2014, members of the 53rd Anti-Aircraft Brigade of the Russian Armed Forces delivered to the DPR a partial component of a surface-to-air missile system, a Buk Transporter Erector Launcher Radar, or Buk TLAR. Less than 24 hours later, the DPR fired that weapon at civilian traffic skies, killing 298 civilians on board Malaysian Airlines Flight MH17. The shootdown was an offense under the Montreal Convention. The Russian officials who provided the Buk knew the DPR was infamous for targeting civilians. They also knew that this weapon could not reliably distinguish civilian from military targets. Accordingly, providing the Buk was an offense under Article 2 of the ICSFT. Russia violated that treaty by failing to take measures to prevent this offense and then failing to investigate and prosecute it. I note two preliminary points. First, other judicial bodies have ruled on the MH17 shootdown, and they have rejected Russia's narrative on both the facts and the law. The court may wish to consult, in particular, the decisions of the European Court of Human Rights and the District Court of The Hague, excerpted at tabs 20 and 22 of your folder, which, among other things, document Russia's falsification and manipulation of evidence. Second, Russia's approach to Flight MH17 in this case has fundamentally changed. In its counter-memorial, Russia did not dispute several key points of fact and law. It did not dispute that the DPR shot down Flight MH17. It did not dispute that members of the 53rd Anti-Aircraft Brigade supplied the Buk TLAR. It did not dispute that the DPR acted unlawfully. It did not present evidence disputing Ukraine's expert testimony that the Buk TLAR was incapable of distinguishing civilian from military aircraft. And it did not deny that firing such a weapon establishes intent under any interpretation of the Montreal Convention. Only in its rejoinder did Russia contest these points in violation of Article 49(2) of the Court's rules. As Judge Greenwood explained in Whaling in the Antarctic, quote, "A state should never hold part of its case, whether argument or evidence, in reserve for a second round," end quote. More importantly, there is a reason Russia initially did not dispute these points. They are indisputable. Madam President, members of the Court, I'll now address the commission of a Montreal Convention offense. A person commits an offense under Article 11B if he or she unlawfully and intentionally destroys an aircraft in service. Overwhelming evidence proves that the DPR destroyed Flight MH17 and acted both unlawfully and intentionally. Unlawfulness is straightforward. As explained in the Commonwealth implementation kits for the counterterrorism conventions, the Montreal Convention's unlawful requirement, quote, excludes from the scope of the offense conduct which is legally justifiable or done with legal authority, such as preventive action by police. The DPR had no legal justification and no legal authority to fire deadly weapons in Ukraine, whatever type of aircraft they meant to destroy. In its rejoinder, Russia belatedly seeks to cloak the DPR's actions in international humanitarian law. But it is well settled in international law that a non-privileged combatant can be prosecuted for violating domestic law. The Hague District Court correctly recognized this point. Quote, "In the absence of combatant privilege, killing a soldier warrants punishment as much as killing a civilian, and shooting down a military aircraft warrants punishment as much as shooting down a civil aircraft, end quote. Assessing the facts, the court concluded the DPR members lacked any such privilege. Russia offers no argument to the contrary. It's worth pausing on the importance of the unlawful element. Russia highlights various incidents where the Montreal Convention was not invoked, but ignores an obvious reason why. In those cases, no one appeared to act unlawfully. For instance, Russia highlights the loss of Siberian Airlines Flight 1812 in 2001 in the course of joint Ukrainian-Russian military exercises in Crimea. I note that unlike Russia in the case of MH17, Ukraine compensated the families. Ukraine also does not accept Russia's account of this incident. But the more important point today is that the Ukrainian military plainly had legal authority to conduct a training exercise. The DPR did not have authority to fire an anti-aircraft weapon. The DPR also acted intentionally for two independent reasons. First, there's no dispute that the DPR intended to destroy an aircraft in service, and Article 11B does not require additional proof of intent to destroy a civilian aircraft. Second, even if such specific intent were required, it was satisfied here when the DPR fired a weapon knowing it could not distinguish civilian from military aircraft. The proper place to begin is the text of Article 1.1. The act that must be done intentionally is destroying an aircraft in service. Russia's position that the DPR hoped to destroy a military aircraft in service concedes the point. The DPR intended to destroy an aircraft in service. Article 11B does not refer to intentionally destroying a civilian aircraft in service. Russia is asking the court to read into the treaty a word that is not there. The Hague District Court similarly rejected a defense based on an allegedly mistaken target. As a matter of domestic criminal law, a killing is intentional even if the wrong victim is killed. The court explained that, quote, this also applies to intentionally and unlawfully causing an aircraft to crash. If, in retrospect, it turns out that a different type of aircraft than the intended type was shot down, the definition of the offense is still met. The Hague District Court was not applying the Montreal Convention, but it is striking that it found, on the same facts, the DPR members intentionally and unlawfully destroyed an aircraft. That is precisely how the Montreal Convention defines an offense. This intent element of Article 1 is not modified by Article 4.1, which reads, this convention shall not apply to aircraft used in military, customs, or police services. Article 4.1 describes the objective circumstances in which the convention, quote, shall not apply, end quote. If a military aircraft had been destroyed, the convention would not have applied, but a civil aircraft was destroyed. So the convention is not being applied to aircraft used in military service. Article 4.1 must also be read in context. Consider its neighboring subparagraph. Like in other counterterrorism treaties, Article 4.2 provides that the treaty shall apply only to transnational incidents. But a perpetrator does not need to intend to destroy a transnational flight versus a domestic one. As Professor Kai Ambos explains, quote, this element is not part of the offense definition, but rather a jurisdictional rule that limits the application of the respective convention to terrorist offenses with a cross-border dimension, end quote. Article 4.1 is written the same way. It likewise establishes only a jurisdictional rule, not a part of the offense definition. Russia also ignores the Montreal Convention's stated object and purpose of deterring unlawful acts against the safety of civil aviation. Note the focus on unlawful acts, not intentional acts, as this case painfully illustrates, those who unlawfully target aircraft of any kind cannot be trusted to keep civil aviation safe. But, Madam President, members of the Court, even if intent to destroy a civilian aircraft were required, the destruction of Flight MH17 was still intentional. Firing a weapon that is incapable of distinguishing military from civilian targets into civilian trafficked airspace establishes intent to destroy a civilian target. The capabilities and practical operation of the Buk system are explained in the testimony of Dr. Anatoly Skorik, a colonel and professor at Kharkiv Air Force University. I'd like to acknowledge that Dr. Skorik has taken time from his important responsibilities in Ukraine to be here today. Dr. Skorik explains that Buk operations are normally carried out under the direction of a combat control center. A single TLAR can operate autonomously, but with severe limitations. In autonomous mode, a commander must make firing decisions on the basis of the TLAR's sparse indicator screens and friend or foe system. This system, however, only identifies allied military aircraft as friends. Everyone else, military or civilian, is marked as a foe. The aiming screen provides information about a target's location and general parameters, but not enough information to tell a civilian plane from a military plane. Dr. Skorik therefore concludes, quote, "The technical capabilities of the Buk M1 TLAR in autonomous mode do not make it possible to distinguish a civilian aircraft from a military one, and this situation is further exacerbated under highly stressful conditions experienced by the combat crew," end quote. Dr. Skorik's conclusion is shared by the government of the Netherlands. Quote, "The Buk system was not capable of distinguishing between enemy military aircraft and civilian aircraft," end quote. Only in its rejoinder does Russia respond with an opinion by Lieutenant Colonel Yuri Bezborodko. Ukraine objects to the admissibility of this untimely submission. More importantly, Bezborodko concedes every key point. Begin with the TLAR's aiming system. Bezborodko admits that this system classifies a target as ballistic, helicopter, or aerodynamic. It does not distinguish types of airplanes. He then admits that, quote, "In practice, it is rarely possible to unambiguously determine the type of airborne target based solely on the performance of this system," end quote. That is consistent with Dr. Skorik's testimony. A Dutch police report, which Russia embraces and submitted in its rejoinder, further explains why the available radar signals are insufficient to distinguish military from civilian aircraft. The size of a blip on the screen may vary for different kinds of aircraft, but that is only helpful information when multiple blips are in view. And in order to avoid detection, quote, "An autonomous TLAR will limit its radar image. This diminishes its capacity to identify a target," end quote. The Joint Investigation Team agrees. Bezborodko also points to the TLAR's camera, but he makes a critical concession. Quote, "Adverse weather conditions, cloud cover, and a distance to the target can make identification difficult," end quote. Difficult is an understatement. As the Dutch police explain, quote, "If a target is flying above the clouds, it is out of reach of the camera. This limitation is foreseeable by the TLAR's crew," end quote. The Joint Investigation Team notes that this was the case at the relevant time. Quote, "On a cloudy day, like the afternoon of 17 July 2014, the TLAR's camera cannot be used," end quote. Finally, Bezborodko admits that, quote, "Difficult ground situation, time pressures, and a certain extreme situation have an impact on the process of combat work," end quote. This again is consistent with Dr. Skorik's explanation that a Buk TLAR in autonomous mode must make firing decisions in a matter of seconds. To summarize, every material fact is undisputed. Ukraine's expert, Russia's expert, the Dutch police, and the JIT agree that the friend or foe system cannot distinguish a civilian aircraft. All agree that in practice, the crew cannot use the available targeting information to determine aircraft status. All agree that in autonomous mode, the TLAR's radar field is narrow, limiting its ability to compare multiple objects. All agree that the camera cannot see a plane flying above clouds. And all agree that the crew must make lightning-quick decisions. Ultimately, Bezboroko only disagrees with Dr. Skorik's choice of words. Dr. Skorik concludes from all of this that the Buk TLAR in autonomous mode lacks a practical ability to distinguish civilian from military aircraft. Bezboroko concludes that civilians being hit is, quote, inevitable, end quote. These are two ways of saying the same thing. Once this factual point is settled, the legal analysis is straightforward. On any interpretation of Article 1.1b, intent is established by proof that the perpetrator fired at civilian traffic skies with a weapon that could not distinguish civilian from military aircraft. The word intentionally has an ordinary legal meaning. There are degrees of intent, and a purpose of causing a specific consequence is just one of those degrees. For example, Professor Ben Saul explains that an attack targeting a military installation, but with knowledge that civilian aircraft are there and will be destroyed, constitutes intentionally destroying an aircraft under the Montreal Convention. Russia's own criminal code reflects that, quote, an act committed with direct or indirect intent shall be recognized as a crime committed intentionally, end quote. This includes where, quote, the person realized the social danger of his or her actions, end quote. This, at a minimum, describes the intent of a person who endangers civilians by firing a weapon he knows cannot distinguish military from civilian aircraft. Russia invites this court to consider intent in light of IHL, but doing so would only confirm Ukraine's conclusion. As this court explained in its nuclear weapons advisory opinion, quote, states must never make civilians the object of attack and must consequently never use weapons that are incapable of distinguishing between civilian and military targets, end quote. The ICTY, applying this principle, confirms that the question is not whether the weapon is indiscriminate in some abstract sense, but in the circumstances in which it is used. It therefore does not matter whether there could be some theoretical set of circumstances, no time pressure, no clouds, a wide radar screen with plentiful blips to compare, where a Buk TLAR commander might be able to identify a civilian aircraft. Under the real-world circumstances faced by the DPR members who fired the missile, the Buk TLAR could not distinguish civilian from military targets. Using that weapon in those circumstances constitutes making civilians the object of attack. In other words, using that weapon in those circumstances constitutes intentionally destroying a civilian aircraft. Madam President, members of the court, since the DPR's destruction of Flight MH17 violated the Montreal Convention, it was an act which may not be funded under Article 2.1a of the ICSFT. There is no serious dispute that Russian officials, including members of the 53rd Anti-Aircraft Brigade, provided the Buk TLAR that was used to commit this act. On this point, the Dutch police and the independent investigator Elliot Higgins submitted detailed statements specifically for this case. Russia ignores them. The Buk was provided knowing it was to be used to commit a terrorist act. As Professor Tuvnan established, providing a weapon to a group notorious for committing acts covered by the Convention establishes the required knowledge. A United States court reached the same conclusion in a case specifically about flight MH17 and specifically brought under legislation implementing the ICSFT. The court held that if the victims' families can prove that the DPR carried out attacks on civilians and that these attacks were widely reported, that would establish that the DPR's funders knowingly financed terrorism. That is exactly what Ukraine has proved in this case. By the summer of 2014, UN monitors and others extensively documented the DPR's pattern of committing terrorist acts. The brutality of Igor Girkin, the specific DPR leader who requested the book from his Russian benefactors, was particularly infamous. But here, knowledge can be established with even more granularity. Members of a Russian air defense brigade surely knew the limitations of the system they were providing. They knew the implications of providing a Buktilar alone. They knew the skies were open to civilian traffic. And they knew that the DPR would have no practical ability to distinguish military from civilian targets. In short, they knew that striking civilian aircraft was, in the words of Russia's own expert, inevitable. Russian officials provided the Buktilar in the knowledge that it was to be used to achieve this inevitable result. So they knew that the Buk was to be used to commit a Montreal Convention offense, making these officials guilty of terrorism financing under Article 2.1 of the ICSFT. The destruction of flight MH17 is another tragic example of the consequences of Russia's total non-cooperation. Under Article 18 of the ICSFT, Russia had an obligation to take practicable measures to prevent terrorism financing. It would have been practicable for Russia to instruct its officials not to supply the DPR with weapons, and at the very least, not to supply a partial system unable to distinguish civilian from military targets. But Russia did nothing of the sort. Russia also could have policed the border. On the 24th of May 2014, the State Border Guard of Ukraine sent one of many requests to the Russian border guard. Ukraine urged, in the interest of safeguarding civilians specifically, that Russia urgently implement measures to stop the smuggling of weapons across the border. Russia ignored that plea. It did not even respond until months after the destruction of flight MH17. And then, the Russian border guard deflected responsibility, making a bizarre claim that it had no authority to address, quote, the passage of vehicles transporting cargo, end quote. That is, Russia's border guard disclaimed authority to guard Russia's border. Had Russia answered Ukraine's call to cooperate in good faith, no Buktilar could have entered Ukraine on the 16th of July, 2014. In legal terms, this practicable measure could have prevented an Article 2 offense. In human terms, 298 people would still be alive. The 3 infants on board would be 9 years old today. These were preventable deaths. Russia could have prevented them. After those deaths, Ukraine confronted Russia with allegations that the supply of the Buk constituted an Article 2 offense. Article 9 of the ICSFT required Russia to investigate that allegation in good faith. Article 10 required Russia to prosecute or extradite the perpetrators. Instead, Russia obstructed multilateral efforts to investigate and prosecute those responsible. Most brazenly, this past February, President Putin bestowed on the 53rd Anti-Aircraft Brigade the honorary title of Guards for their, quote, mass heroism and valor, end quote. That is how Russia responds when its own officials finance terrorism and cause mass civilian destruction. Not cooperation, not prevention, not investigation, not punishment. Instead, high honors. That is not the act of a state that takes its obligations under the Convention seriously. Madam President, members of the Court, the ICSFT also makes it an offense to finance acts covered by the Bombings Convention. Ukraine's largest cities, hundreds of kilometers from any fighting, faced a campaign of such terrorist bombings. These bombings targeted a member of parliament in Kiev and the leader of an NGO in Odessa. Kharkiv, Ukraine's second largest city, was hit the hardest. One resident described the atmosphere in the city this way, quote, "The anxiety raised by the bombings is painful. That's the whole point of terrorist acts, to bring people to a pitch of fear where they can be easily broken," end quote. The bombs and money to conduct this campaign came from Russian persons. Yet once again, Russia did nothing to prevent this financing and nothing to investigate it or suppress it. Time does not permit me to address every part of this bombing campaign and the way it was financed, nor is that necessary. Russia disputed almost nothing about this subject in its counter-memorial. As with Flight MH17, Russia improperly makes new arguments in its rejoinder. For example, in its counter-memorial, Russia did not dispute the supply of MROA rocket launchers, which are possessed only by the Russian military. Nor did it dispute the fact that terrorists use this Russian weapon to attack the regional headquarters of a major bank. Only in its rejoinder did Russia offer a purported expert to try to explain away these inconvenient facts. This untimely expert opinion, another one, should not be admitted. But even that is an exception. Mostly, Russia just ignores the evidence. I will therefore focus on two serious bombings in Kharkiv and the nearly undisputed evidence that they were financed by Russian persons. When the Court revisits the written pleadings, it will see similar patterns in other incidents and a similar failure by Russia to meaningfully engage. The Stina Rock Pub is a nightclub in downtown Kharkiv that was popular among supporters of Ukrainian unity. On the evening of Sunday, 9 November 2014, an SBM limpet mine exploded inside. OSCE monitors visited the scene, reporting that, quote, "The explosion resulted in a number of injured people," end quote. In its counter-memorial, Russia did not dispute that this was an offense under the Bombings Convention. Only in its rejoinder did Russia contest that point. But the Stina attack fits squarely within the Bombings Convention. Stina Rock Pub was a place of public use. And detonating a military-grade mine inside of a crowded bar undeniably reflects an intent to cause death or serious bodily injury. In paragraph 476 of its rejoinder, Russia now calls the Stina Pub a, quote, "military target," end quote, and claims that it falls under the military exclusion clause in Article 19. The Court should pause here. Russia is saying that a crowded nightclub is a legitimate target. The callousness of that argument speaks volumes. It also has no basis in fact or law. Russia's explanation is that members of a Ukrainian battalion who had returned from fighting in Donbass were at the nightclub. Russia bases this argument on rumors printed in a pro-Russian blog, which itself admits it is, quote, "impossible to confirm this fact," end quote. Russia also does not identify what armed force, as that term is defined in IHL, it believes carried out this attack. The bombing thus cannot be an activity of armed forces during an armed conflict that is excluded under Article 19. While the Court may stop there, the attack is separately covered by Article 2.1b of the ICSFT. Even in its rejoinder, Russia does not address that point. I will just add two brief observations. First, the ICSFT has no armed forces exclusion akin to Article 19 of the Bombings Convention, so Russia's exclusion defense is irrelevant. Second, Article 2.1b covers acts intended to harm civilians and any other person not taking an active part in the hostilities in a situation of armed conflict. As the U.S. State Department explained, this language was specifically adopted, quote, to ensure that the convention encompassed the financing of attacks on off-duty military personnel, end quote. Even assuming some off-duty servicemen happen to be at the nightclub, this is precisely the type of attack Article 2.1b was meant to cover. Madam President, the Russian persons who delivered limpet mines to Kharkiv committed a terrorism financing offense under Article 2.1. Russia does not dispute that the limpet mine was provided with knowledge it was to be used to commit a terrorist act. There's no innocent explanation for delivering a bomb to a peaceful city. Russia instead denies that Russian persons supplied the mine. The evidence says otherwise. An SBM limpet mine is typically used in naval warfare. We're not talking about an improvised bomb someone could build at home. Only militaries have it. And Russia offers no evidence this was a Ukrainian military mine. Major General Ivan Gavriluk of the Ukrainian Armed Forces testified, without dispute, that Ukraine had no limpet mines in Donetsk and Luhansk oblasts. Less than 2 weeks after the Stina attack, Ukrainian law enforcement discovered in the Kharkiv region another SBM limpet mine, marked with the number 90. Russia ignores this evidence. As General Gavriluk testified, this marking reflects a 1990 production date, and quote, the UAF has not had any limpet mines manufactured after 1987 in its service, end quote. Russia ignores that too. This mine could only have come from Russian sources. In other words, undisputed evidence shows that Russian persons delivered limpet mines to Kharkiv. That is more than enough to establish a financing offense. But there is even more evidence tying the perpetrator, Marina Kovtun, to Russian persons. That evidence includes Kovtun's own testimony, which Russia focuses on and calls unreliable. Yet there is also hard evidence, which you can find at tabs 39 through 42 of your folder, corroborating what she said. Border crossing records, intercepted conversations, seized assault rifles, which were registered with Ukrainian military units in Crimea until the occupation. More fundamentally, the court should view the record as a whole. Russia has not disputed that Russian persons delivered an overwhelming amount of weapons into Ukraine in 2014 and 2015. During the same period, a Russian-made, military-grade mine exploded at a nightclub popular with supporters of the Revolution of Dignity. It defies credulity to think this attack was financed by anyone other than Russian persons. Russia offers even less of a defense of the deadly bombing of a Kharkiv peace rally. On the 22nd of February 2015, Ukraine commemorated 1 year since the revolution. The people of Kharkiv gathered to rally for peace and unity. They were greeted by a MON-100 anti-personnel mine. This terrorist attack killed 3 civilians and injured many more. Like a limpet mine, the MON-100 is a Russian military weapon. The 100 in its name means it has an intended lethal range of 100 meters. Russia does not dispute that the rally bombing was an offense under the Bombings Convention, and also an act covered by Article 2.1b. Russia also cannot deny that anyone who delivered an anti-personnel mine to Kharkiv knew it was to be used to commit a terrorist act. Russia's only cursory defense is to say there is, quote, no evidence, unquote, the mine came from Russia. Russia is again ignoring the record. The relevant evidence was summarized by a Ukrainian court judgment in your folder at tab 45. It includes a recorded conversation of the perpetrator speaking with other inmates. The evidence also includes a perpetrator's emails, quote, with officers of the Russian Special Services, end quote. Russia engages with none of this. But as with the Stina Rock pub bombing, there is a more fundamental point. Anti-personnel mines are not readily available. Undisputed evidence shows an influx of Russian weapons during this time period into Ukraine in general and Kharkiv in particular. The only reasonable conclusion is that when terrorists use a Russian-made, military-grade mine against patriotic Ukrainian civilians rallying for national unity, that mine came from Russia. As I noted at the outset, these two bombings are just illustrative examples. Kharkiv faced a rash of bombings, a similar pattern repeated across the country. It would have been practicable for Russia to prevent the supply of its own military's mines into Ukraine. But Russia took no practicable measures to prevent this terrorism financing, nor is there any evidence that Russia did anything to investigate or suppress this terrorism financing. Instead, Russia chooses to defend the legitimacy of bombing nightclubs. Madam President, members of the court, the evidence is unequivocal. Russia violated the ICSFT in connection with the financing of attacks on civil aviation and terrorist bombings. I now ask, Madam President, that you call upon Ms. Marnichik.
I thank Mr. Zients, and I now invite Ms. Marnichik to address the court. You have the floor, Madam.
Madam President, members of the court, it is a pleasure to appear before you today on behalf of Ukraine. As Professor Tuvenan established earlier today, it was well known that in 2014, the DPR and LPR were attacking civilians as part of a campaign of intimidation and terror. Yet funds continued to flow across the border from Russian persons into the hands of those committing these terrorist acts. Ukraine repeatedly sought assistance from Russia to prevent this financing, raising grave concerns about the money and weapons flowing from Russia's territory. But instead of cooperation, instead of taking measures to prevent and counter preparations for the commission of terrorism financing offenses, Russia did not engage in any meaningful way. As Ukraine's requests for cooperation were met with silence, funds continued to flow to DPR, LPR, and other groups engaged in terrorist acts. Mr. Zients has already spoken of the knowing funding of terrorist acts under Article 21A. I will speak of the knowing funding of terrorist acts covered by Article 21B, specifically shellings that targeted civilians. After speaking in some detail of these terrorist acts and the supply of weapons used to commit them, I will then return to Russia's utter disregard for its obligations under the ICSFT to prevent and counter preparations for terrorism financing, as well as Russia's failure to cooperate in the investigation and suppression of terrorism financing. In the span of 30 days, in January and February 2015, shells rained down on civilians in major Ukrainian cities far from the contact line, coinciding with an intense period of diplomacy and negotiations, which ultimately led to the Minsk II agreement. Each of these attacks involved multiple launch rocket systems from Russia. Each attack was widely publicized. And after each of these attacks, Russian officials continued to supply DPR fighters with more of these weapons. BM21 grads were supplied to DPR in early January. Days later, BM21 grads were used to shell a civilian checkpoint at Volnovakha. After Volnovakha, more BM21s were sent to the DPR fighters. 11 days after Volnovakha, a neighborhood in Mariupol was shelled. Then yet another MLRS was provided to the DPR, this time a BM30 Smerch. And 17 days after Mariupol, civilians were shelled in Kramatorsk. By supplying weapons in these circumstances, Russian persons committed terrorism financing offenses within the meaning of Article 2 of the Convention. The first in these series of attacks was the shelling of a civilian crossing and vehicle inspection point near Volnovakha, the Buhas checkpoint. At 14:25 on a Tuesday afternoon, the 13th of January 2015, at least 88 rockets rained down on a line of civilian vehicles, hitting a bus full of pensioners. 12 passengers were killed and 19 were injured. In the months leading up to the attack, vast amounts of monetary support and Russian weapons flowed to the DPR and other illegal armed groups in eastern Ukraine. This large-scale effort, both overt and covert, raised millions of rubles and provided weapon systems and other military equipment to the same groups publicly named by the OHCHR as engaging in a campaign of intimidation and terror against Ukrainian civilians. It is undisputed that in the weeks prior to the Volnovakha attack, Russian officials supplied illegal armed groups with BM21 grads, the weapon used in the attack in Volnovakha. The supply of these weapons was done with the knowledge that they would be used to carry out a terrorist act under Article 2.1 of the ICSFT. Russian officials knew to whom they were supplying these destructive weapons. The DPR and other illegal armed groups had a well-documented track record of targeting civilians. Knowingly providing such a group BM21 grads is an offense under Article 2.1. Once the weapons were provided, the Article 2 offense was complete. I respectfully remind the Court that Article 2 offenses are offenses regarding funding. Indeed, Article 2.3 confirms that a terrorist financing offense is complete, regardless of whether the funds are actually used in the end to carry out a terrorist act. That said, what happened after Russian officials provided the DPR with BM21 grads was, unfortunately, predictable. The weapons were used against a group of civilians lined up at a civilian vehicle inspection point 10 kilometers away from the contact line. As Professor Tuvenan established, an act whose certain consequence is civilian death is, quote, an act intended to cause death to a civilian under ICSFT Article 2.1b. It is undisputed that firing B-21 grads at the Buhas civilian checkpoint was certain to have this result. It was well known that the checkpoint attracted long lines of civilian cars, especially in the afternoon. Satellite imagery captured on the morning of the attack shows a long line of civilian vehicles waiting to be screened. This image and other satellite imagery Ukraine presents to the Court today is available in the Judges folder at tabs 46 and 48 and is also in the record at Ukraine's reply, Annex 2. The checkpoint facility itself was small, approximately 100 meters by 100 meters. General Brown, Ukraine's military expert, who is here as part of Ukrainians' delegation today, and whose expert reports are excerpted in the Judges folder at tab 47, has explained that at the distance DPR fighters fired the BM-21, rockets fall throughout a 1,300 by 700 meter area. This spread of fire guaranteed that civilians lined up at the inspection point would be harmed in the attack. This is sufficient to satisfy an act intended to cause death to a civilian under Article 21b. However, even under Russia's interpretation that the attacker must have intended civilian harm, the evidence demonstrates that the DPR intended to harm civilians. Satellite imagery confirms that Bujas was a civilian checkpoint designed to slow down cars and conduct vehicle inspections along a busy roadway. Its layout was consistent with U.S. peacekeeping guidance on a setup of police checkpoints. It was not a fortified military installation. Russia's attempt to compare the civilian inspection point to a DPR frontline combat position near Volnovakha that was attacked by Ukrainian forces 15 months later only confirms how different these installations were. The undisputed testimony of Maxim Shevkoplas, the Ukrainian border guard official in charge of the Bujas checkpoint at the time, confirms that the facility performed administrative tasks such as inspecting vehicles and cargo. There were no Ukrainian armed forces units or equipment present. It did not play a role in the conflict. Russia also has responded with an academic debate about whether a civilian checkpoint qualifies as a military target under international humanitarian law because there were some small arms and minimal self-defense capabilities there. But the court need not engage in this exercise because whatever the civilian checkpoint status was, General Brown has explained that there was no plausible military explanation for DPR fighters to attack this civilian checkpoint. The only explanation that makes sense is an objective of harming civilians gathered at the checkpoint. Russia's arguments to the contrary are not supported by the evidence. Russia theorizes that the DPR may have been trying to neutralize the checkpoint for military reasons. But General Brown explains that if that was the case, the BM-21 Grad was the wrong weapon to use. Russian military doctrine, which the DPR presumably followed since they were using Russian weapons, prescribes that the minimum target size for a BM-21 is 400 meters by 400 meters. The Bujas checkpoint was 4 times smaller than the minimum target. Russia's military expert argues that it was not prohibited to use a BM-21 Grad in these circumstances. But that misses the point. As General Brown explains, artillery doctrine prescribes a minimum target size because if a target is too small, the rockets will likely miss and the target will not be destroyed. Indeed, this is precisely what happened at the Bujas checkpoint. None of the BM-21 rockets actually hit the checkpoint facility, but they did hit a civilian bus full of pensioners. As explained by General Brown, none of Russia's other arguments work either. If DPR fighters actually intended to destroy the checkpoint, they had access to more precise and effective weapons for the target. Russia calls attention to the presence of Kiev 2 battalion personnel at the checkpoint. But Kiev 2 was a police patrol unit that assisted the border guard with running the checkpoint. They did not have a combat role. Russia speculates that the attacks were part of a coordinated artillery campaign against locations deep behind the front line. But there is no evidence to support Russia's theory. Russia further suggests that the attack could have been a precursor to a ground offensive toward the checkpoint. Ukraine's satellite imagery experts confirmed there was no concentration of DPR fighters ready to follow the BM-21 Grad attack with a larger ground offensive. In sum, Russia's theories do not line up with reality, and they are not supported by the evidence. Attacking this small vehicle inspection post 10 kilometers behind the contact line with BM-21 Grads had no military purpose. Attacking a line of civilian cars with a weapon designed to blanket a large area with rocket fire made sense only for someone wishing to cause death and serious injury to civilians. Now, Ukraine does not have to prove both a purpose to intimidate a population and a purpose to compel a government to act under ICSFT Article 21b. But based on the nature and context of the act, both are present here. The only plausible explanation for the attack on the Buhas checkpoint was its value in intimidating the civilian population known to line up at that checkpoint. As already mentioned, the BM-21 is designed to be used where there is a large area of troops or vehicles gathered in the open. With no credible military purpose for this attack, the only conclusion is that it was another volley in DPR's reign of terror designed to intimidate civilians. Consistent with its name, Grad means hail in Russian. One BM-21 launcher fires 40 rockets in as little as 20 seconds. Being on the receiving end of such a hail of rockets, as General Brown has explained, quote, tends to cause fear, confusion, and panic. He goes on to say that it's, quote, highly frightening and creates a sense of helplessness for those subject to the attack. The timing of this incident is also telling. January through February 2015 was an intense period of diplomacy within the trilateral contact group that ultimately led to the Minsk II agreement. During this period, DPR and LPR were making demands for Ukraine to change its constitutional structure and pressuring Ukraine to make concessions. It is not a coincidence that a series of high-profile attacks against civilians happened during this short time frame, precisely when they would be most useful to compelling the government of Ukraine to act. The second shelling incident was in Mariupol. Just 11 days after the attack on the civilian checkpoint near Volnovakha, on the Buhas checkpoint, on the morning of Saturday, the 24th of January, 2015, DPR deployed a barrage of no less than 154 BM-21 rockets against the Vostochny neighborhood of Mariupol, a densely populated residential area. 30 civilians died, including one child, and 118 people were injured. This second high-profile shelling of civilians with a Russian weapon damaged at least 53 residential buildings, 4 schools, 3 daycare centers, 8 grocery stores. Those Russian persons supplying the DPR with BM-21 Grads were well aware of the DPR's reign of intimidation and terror, its downing of Flight MH17, the attack on a bus full of pensioners at a civilian checkpoint just days earlier. To be clear, within days of killing civilians in Volnovakha with BM-21 Grads, Russian officials supplied the DPR with more BM-21 Grads. This act was plainly done with the knowledge of how such weapons would be used under Article 2.1 of the ICSFT. Accordingly, an Article 2 offense was completed once Russian officials delivered more BM-21 grads in the aftermath of Volnovakha. Per ICSFT Article 2.3, it does not matter what happened next. But regrettably, predictably, what happened next was the DPR used those Russian-supplied weapons against civilians again, this time in the residential neighborhood of Mariupol. The shelling of the Vostochny neighborhood was an act intended to cause death to a civilian under ICSFT Article 2.1b. Russia acknowledges there was no military reason to attack the Vostochny neighborhood. Instead, Russia claims that the DPR did not intentionally target the residential neighborhood, hypothesizing a variety of possible alternative targets, without committing to a single theory of which target the DPR fighters actually intended to attack. But once again, Russia's theories do not line up with the evidence. At times, Russia has suggested that Ukrainian National Guard checkpoint number 4014, a position on the edge of the city, was the real target. If so, it is undisputed that this small checkpoint could not have been targeted with 4 BM-21 Grad systems without rockets also raining down throughout the residential neighborhood. General Brown explains that as with the Buhas checkpoint, BM-21 Grads would not have been the right weapon system if that had been the target. Russia also suggests at times that the intended target might have been the Ukrainian National Guard company position number 4013, which was more than 2.5 kilometers away. But that explanation could not be credited with a series of firing errors so far-fetched that one would have to conclude that BM-21 Grads were an indiscriminate weapon in the DPR fighters' incompetent hands. Once again, Russia has many theories, but none are supported by the facts. Russia speculates about potential technical malfunction, but when a BM-21 launcher malfunctions, its rockets fire erratically, impacting unpredictably in a scattered pattern. That was not the case here. Russia has offered no explanation for how the 4 separate BM-21 launchers used in the attack simultaneously malfunctioned in a way that produced a coherent impact pattern throughout the Vostochny neighborhood. With regard to the possibility of human error, Russia hypothesizes that maybe bad target coordinates were given. But the coordinates of the proposed targets, alternative targets, were also known to DPR, and DPR fighters are on record conducting pre-firing checks that would have caught any error in the coordinates. Russia suggests that the shelling was a precursor to a ground offensive toward the city. But as General Brown observes, there was no ground assault. Russia's military expert himself concedes, quote, "I do not see sufficient evidence of the actual attempt to capture Mariupol." Finally, intercepted DPR communications provide additional evidence that the residential area was intentionally targeted. The night before the attack, a DPR member told DPR fighters to hit Vostochny. The next morning, DPR fighters launched a massive strike on the Vostochny neighborhood. And the same DPR member who requested the attack the night before celebrated that it would make the people in Mariupol more afraid. While Russia points to additional intercepts that it claims shows some surprise about this attack on civilians, that does not negate this chilling evidence that some DPR members were rejoicing, and it is not surprising that other DPR members might not have known about the plan. The only plausible explanation is that the Vostochny neighborhood of Mariupol was intentionally targeted. As observed by the UN Undersecretary General 2 days after the attack, quote, Mariupol lies outside the immediate conflict zone. The conclusion can thus be drawn that the entity that fired those rockets knowingly targeted a civilian population, end quote. Once again, while a terrorist act under ICSFT Article 21b need only be shown to have the purpose of intimidation or to compel a government to act, both are present here. The UN Undersecretary General described the Mariupol incident as an attack on a residential neighborhood. Such an attack is an act whose nature is to intimidate a population. And although direct evidence is not required, in this case it exists. Whatever Russia might speculate about others' reactions, there is simply no explanation for a DPR leader rejoicing that the residents of Vostochny will be more afraid. The shelling of Mariupol's civilian population occurred less than 2 weeks after the DPR killed the bus full of civilian pensioners at the Buhas checkpoint in Volnovakha, and just 1 week before a major diplomatic conference that would result in the Minsk II agreement. This was a period when political leverage was crucial, and the nature and context of events shows that the DPR saw these high-profile shelling attacks on civilians as providing leverage. Considering this political context, the shelling of the Vostochny neighborhood of Mariupol had the purpose of compelling the Ukrainian government to act. The final act I will discuss in early 2015 was the attack on the city of Kramatorsk. On 10 February 2015, DPR launched a series of BM-30 rockets, bombarding a residential area of the city. The attack, conducted at a Tuesday afternoon around lunchtime, damaged 15 residential buildings, as well as a kindergarten, an art school, a local hospital. 7 civilians were killed and 26 were seriously injured, including 5 children. Russian officials who supplied the DPR with a BM-30 Smerch, were well aware of the DPR's reign of intimidation and terror, its downing of Flight MH17, the attacks on Volnovakha and Mariupol. Russian officials knew that a barrage of rockets had killed a bus full of pensioners at a civilian checkpoint in Volnovakha, an act condemned by the UN Security Press Statement as reprehensible. Russian officials knew that less than 2 weeks earlier, an even larger barrage of rockets had landed on a residential neighborhood in Mariupol, an act the UN Undersecretary General observed knowingly targeted a civilian population. With this knowledge of how the weapon would be used under ICSFT Article 2.1, Russian officials provided the DPR fighters with a BM-30 Smerch. The BM-30 Smerch is a more sophisticated multiple-launch rocket system than the BM-21. Unlike the BM-21, where the rocket warhead explodes on impact, each BM-30 rocket contains 72 cluster munitions. These cluster munitions are released from the rocket as it flies over its intended target. After the cluster munitions are released, the rocket continues on its path and eventually falls to the ground. Supplying the DPR fighters with this advanced multiple-launch rocket system after they had used similar systems against civilians in Volnovakha and Mariupol completed an Article 2 offense. As already mentioned, under ICSFT Article 2.3, it does not matter what happened next. The funds were provided knowing that they were to be used in terrorist acts, whether those acts were ultimately carried out or not. But once again, Predictably, the funds were in fact used against civilians, this time attacking the center of a residential neighborhood in Kramatorsk, more than 50 kilometers from the contact line. Using the BM-30 Smerch against the residential neighborhood in Kramatorsk was an act intended to cause death to a civilian under ICSFT Article 21b. As with the attack on the Vostochny neighborhood of Mariupol, Russia agrees there was no military reason to attack a residential neighborhood in Kramatorsk. Once again, Russia has various theories for what might have happened on that fateful day in February 2015. For example, Russia hypothesizes about various technical malfunctions and human errors that could have resulted in rockets overflying an airfield 5 kilometers away and hitting the residential area instead. General Brown has looked at those theories and found them unsupported by the evidence. After the attack on Kramatorsk, BM-30 debris and cluster munition impacts were identified across an area spanning more than 5 kilometers. As General Brown explains, he and Russia's expert agree that the cluster munitions from one salvo of BM-30 rockets cannot fall 5 kilometers from each other. In other words, if DPR had only targeted the airfield, cluster munitions would not have impacted in the residential area. This confirms that the airfield and the residential area were targeted separately. Russia's suggestion that human error, faulty rockets, or technical malfunction could have led to a 5-kilometer overflight are also highly unlikely. General Brown and Russia's expert agree it is very unlikely the operators of a BM-30 made so many errors while preparing and aiming the launcher that multiple rockets overshot their target by 5 kilometers. Further, as General Brown explains, faulty rockets typically burn out and fall short of their intended target. They do not overshoot. In the very unlikely event that some BM-30 rockets malfunctioned and overflew the airfield, the rockets' timing mechanisms would have still been programmed to release their cluster munitions over their intended target, supposedly the airfield. But instead, cluster munitions rained down on the residential area in Kramatorsk. The likelihood that multiple BM-30 rockets experienced a simultaneous overflight and timing mechanism malfunction is near zero. Russia's expert does not dispute that conclusion. Madam President, members of the Court, at this stage, it's important to step back and consider Russia's explanation for these attacks together. According to Russia, a once-in-a-lifetime confluence of errors occurred in Kramatorsk, which could have led to cluster munitions falling anywhere, but instead, they landed in a residential area in a major city. This coincidence just so happened to take place 2 weeks after another implausible set of errors supposedly occurred in Mariupol, which resulted in more than 150 rockets landing in the center of a residential neighborhood. This also happened 1 month after DPR fighters targeted a civilian checkpoint, killing a bus full of pensioners in an attack that Russia has never been able to explain from a military perspective. Even if any one of these events could be explained in isolation, they cannot be explained in concert. Taken together, these were all acts intended to cause death or serious bodily injury to civilians far from the conflict zone. Targeting civilian areas of a major city far from the conflict zone has the purpose of intimidating a population under ICSFT Article 21b. For the attack on Kramatorsk, the political context is particularly clear, as the city was attacked just one day before Ukraine, Russia, France, and Germany were scheduled to meet at Minsk to negotiate a possible peace plan. The participants would have undoubtedly had this shelling and the other recent shellings in mind as they met to negotiate. The nature and context of the attack indicate that this was precisely the point. Following these three high-profile shelling attacks on civilians, the Minsk II agreement was signed in February 2015, and attacks on civilians subsided for a time. But the financing continued. Russian persons continued to supply funds to the DPR. Ukrainian civilians remained vulnerable to DPR's reign of intimidation and terror. In January and February 2017, that reign of intimidation and terror continued with the shelling of Avdiivka. Unlike Volnovakha, Mariupol, Kramatorsk, Avdiivka was quite close to the contact line, and many attacks in that city did target Ukrainian military personnel and equipment. But the DPR did not stop there. The DPR also carried out attacks against a northern residential area of the city where there was no evidence of a Ukrainian military presence. Russia has not provided an explanation for this beyond mere speculation, nor has Russia answered General Brown's conclusions on the inappropriate of using BM-21 grads in this populated area in Avdiivka, which were certain to harm civilians. In sum, despite the DPR's widely publicized history of attacking civilians, despite UN condemnations of these attacks, Russian persons continued to send the DPR a steady supply of weapons and other funds. Once a grad was used against civilians, more would come. In this court, Russia defends these acts of terrorism financing on a massive scale by putting forward post hoc, speculative theories for the DPR fighters' attacks. General Brown has considered and rejected those theories. More to the point, which should be considered regarding the knowing funding of terrorist acts covered under Article 21B is this question. What did those funders know at the time they were sending yet another shipment of weapons across the border to DPR fighters? Here is what those funders knew. They knew about DPR's reign of terror and intimidation. They knew about the shootdown of flight MH17. They knew about the DPR fighters' shellings targeting civilians, which were condemned by UN officials. And what did Russia do to prevent and suppress this financing of terrorism? Nothing. Russia took no practicable measures to stop this terrorism financing. It is to that topic that I will turn to next, but I would defer to Madam President as to whether this would be an appropriate time to break for lunch.
Thank you, Ms. Cheek. Your statement for the time being brings to an end this morning's session. The court will meet again this afternoon at 3 p.m. to hear the remainder of the first round of the oral argument of Ukraine. And as you've suggested, Ms. Cheek, when we resume this afternoon, we shall begin with the end of your statement. Thank you. The sitting is adjourned. The court meets this afternoon to continue the remainder of the first round of the oral argument of Ukraine, and I now give the floor to Ms. Cheek to complete her statement. You have the floor, madam.
Thank you. I will now turn to Russia's violations of the ICSFT. Amid a stream of terrorist acts in Ukraine, amid the flood of Russian funds crossing the border to finance these acts, Ukraine sought cooperation from Russia. Under the ICSFT, Russia could have chosen a lawful path: good faith cooperation to prevent, investigate, and punish terrorism financing. Russia instead chose an unlawful path: delay, inaction, willful blindness, and outright falsehoods, defying its cooperation obligations under ICSFT Articles 8, 9, 10, 12, and 18. These are the violations of the ICSFT from which Ukrainians have suffered. The states parties to the ICSFT noted in the Convention's preamble that, quote, "The number and seriousness of acts of international terrorism depend on the financing that terrorists may obtain." Shelling civilians in peaceful cities far from conflict, detonating bombs at peace rallies, shooting down civilian aircraft. These are very serious acts, and they depended on financing by Russian persons. Yet Ukraine's repeated requests for cooperation from the Russian Federation to help cut off the financing of these terrorist acts fell on deaf ears. Ukrainians suffered through one terrorist act after another from early 2014 to early 2015. In response, Ukraine sent dozens of requests to the Russian Federation, seeking cooperation to prevent and suppress the financing of these acts. Ukraine provided names, bank accounts, websites, information on weapons supply convoys. Ukraine waited for responses and continually asked for cooperation. Ukraine's border guard service made multiple requests for a joint meeting with Russian officials. Russia chose to stay silent. Eventually, the Russian side responded. But those responses only confirmed that Russia had no interest in genuine cooperation to suppress and prevent the financing of terrorism. I should note that Russia's obligations under the ICSFT are not only triggered by requests for assistance. Russia had a duty to be proactive. Yet when it was obliged to act, Russia did nothing. Let me now briefly summarize Russia's specific violations of its cooperation obligations under the ICSFT. For every example that I give here today, there are many more reflected in Ukraine's written pleadings. ICSFT Article 8 requires states parties to take appropriate measures to identify, detect, freeze, and seize funds used to finance terrorism. As I just mentioned, this obligation is not triggered by a request. Russia has an obligation to be proactive. In 2014 and 2015, it was common knowledge that the DPR and LPR were committing terrorist acts in Ukraine. In their push to win political concessions, they engaged in a campaign of intimidation, attacking civilians and killing and seriously injuring many. In Russia, people were openly funding these groups. Russia, therefore, had a duty to identify the funds being used for this purpose and to detect them if they could not easily be identified. If there was reasonable suspicion certain funds were being used to finance terrorism, Russia had a duty to freeze them. But Russia did nothing. Russia defends its failure to act by asserting that Ukraine has not conclusively proven various alleged mental elements of terrorism financing offenses. That is false, but it's also irrelevant to Ukraine's claim under Article 8. Cooperation does not mean demanding conclusive proof, while at the same time closing your eyes to existing evidence. At a minimum, where there was a reasonable suspicion of terrorism financing, Russia had an obligation to temporarily freeze the funds and promptly investigate. Instead, Russia did nothing. Russia also ignored Ukraine's specific requests. To take just one example, on the 29th of August 2014, Ukraine notified Russia of specific individuals and specific bank card numbers being used to finance terrorism in Ukraine. Most of the relevant accounts were at Sberbank, a state-owned bank. Had Russia wanted to cooperate, it could have taken swift action. But Russia did not respond for almost a year. When it did, all Russia said was, quote, "Work to identify the persons mentioned in the note, as well as the details of their bank accounts, is being processed at the current time." This non-response speaks for itself, but let me add two observations. First, when it comes to freezing assets used in terrorism financing, speed is essential. Freezing is a temporary emergency measure. Seizing comes later, after more due process. If reasonable suspicions are not acted on, funds may be used to finance terrorism, and then it's too late. Waiting a year to even begin processing bank account details is not good faith cooperation or compliance with Article 8 of the Convention. Second, at the time Russia responded to Ukraine, Russia mentioned none of its current arguments that are before this court. Russia did not claim that the individual funders lacked knowledge under Article 2. They did not say that there was nothing that gave rise to a reasonable suspicion. Russia could not say that, because for a year it showed no interest in investigating, no interest in determining the culpability of these individuals at all. Again, that is not good faith cooperation that the ICSFT requires. Russia displayed the same indifference under Articles 9 and 10 of the ICSFT. Under Article 9, if Russia received information that a person committed a terrorism financing offense or was alleged to have committed a terrorism financing offense, Russia was obligated to investigate the facts. Under Article 10, Russia was obligated to extradite offenders or to refer them for prosecution, treating the case in the same manner as any other offense of a grave nature. Again, Russia did none of those things. Just a few examples are more than enough to illustrate Russia's violations of Articles 9 and 10 of the ICSFT. In August 2014, Ukraine sent Russia a request for assistance. Ukraine described the terrorist acts being committed by the DPR and LPR, including that they were aimed at intimidation of the population. Ukraine also provided Russia with information about specific persons and legal entities suspected of terrorism financing. This included Putin loyalist Konstantin Molofeev, a major shareholder in Rostelecom, one of Russia's largest state-controlled monopolies. Again, Russia did not respond for nearly a year. When it did respond on the 31st of July, 2015, all Russia could say was, quote, "It was not possible to identify the location of Mr. Molofeev." While Russian authorities apparently did not check his office in Moscow, where American journalists were able to find Mr. Molofeev to interview him in October 2014. It's an understatement to say that Russia did not investigate the information that Ukraine had provided. Russia did nothing. In the same request from August 2014, Ukraine alerted Russia to terrorism financing by Alexander Zhukovsky, who publicly admitted fundraising for the DPR. In November 2014, Ukraine informed Russia of additional terrorism financing offenses committed by Mr. Zhukovsky. When Russia finally responded on 31 July 2015, it said that Mr. Zhukovsky, quote, does not exist in the Russian Federation. Russia apparently did not click the link supplied by Ukraine, which would have taken them to Mr. Zhukovsky's social media page, where he boasted of hosting a fundraiser for the DPR. Russia also apparently did not notice that Mr. Zhukovsky gave interviews to the Russian media, where he was described as a St. Petersburg-based activist. These are surprising activities for someone who does not exist in the Russian Federation. Once again, Russia did nothing. As a final example, Ukraine asked Russia to investigate the, quote, Coordination Center for Assistance to Novorossiya, describing it as one of the centers of financing and provision of assistance to the operations of terrorist organizations in the territory of Ukraine. Once again, Russia ignored this request for a year. When Russia finally responded, it informed Ukraine that the center, quote, does not have electronic accounts, and that military items are not acquired by the group. In this case, Russia appears not to have consulted the center's own website, which has links to electronic bank accounts accepting donations and elsewhere boasts of providing non-humanitarian aid and sending all kinds of useful items to the militia. Again, Russia did nothing. Russia's responses to Ukraine's requests for cooperation are indefensible. That explains why Russia has not even tried to defend them before this court. Instead, Russia argues that in order to even request cooperation, terrorism financing offenses, quote, must be conclusively proven with the requisite specific intent. But that's backwards. Article 9 requires a state to investigate when a terrorism financing offense is alleged. Investigation is what produces the proof. Since Russia's failed to investigate under Article 9, it's perhaps not surprising that it also could not comply with its obligation to prosecute or extradite under Article 10. Ukraine has provided evidence showing the commission of terrorism financing offenses by Russian officials and other Russian persons. At a minimum, the established facts warranted serious attention by Russian prosecutors. Article 10 required Russian authorities to take their decision in the same manner as in the case of any other offense of a grave nature. Instead, Russia did nothing. In short, Russia had no interest in suppressing the financing of terrorism in Ukraine. Russia never investigated allegations of terrorism financing in a timely manner, if at all. Russia never fulfilled its obligations to extradite or prosecute in the same manner it would have for other serious grave crimes. Through this refusal of genuine cooperation, Russia breached its obligations under Articles 9 and 10 of the ICSFT. Russia also failed to offer the greatest measure of assistance to Ukraine in connection with its criminal investigations of terrorism financing, as required by ICSFT Article 12. Ukraine sent many such requests for assistance. Instead of engaging with those requests, Russia did the opposite. Ukraine made at least 12 mutual legal assistance requests related to terrorism financing investigations. For half of them, Russia offered a bare invocation of national security and sovereignty. Russia did not explain how terrorism financing investigations implicated its national security or sovereignty. Indeed, it's difficult to see how providing assistance with a terrorism financing investigation could undermine national security or sovereignty. In Djibouti v. France, this court found that such an unexplained denial of assistance violated a mutual legal assistance treaty. It also violates Article 12 of the ICSFT. In other instances, Russia refused assistance based on supposed, quote, procedural formalities. For example, Russia denied assistance because Ukraine had not supplied the place of birth of potential witnesses. That is not affording the greatest measure of assistance under ICSFT Article 12. Even where Russia responded to Ukraine's requests, it offered no real help. For example, Ukraine sought assistance regarding the supply of weapons to DPR fighters by O. Kulugina, a Russian citizen. Ukraine asked Russia for information on Kulugina's crossings of the Ukraine-Russia border. Rather than offer the greatest measure of assistance, the Russian prosecutor's office took it upon themselves to conclude that Ukraine didn't need this assistance because it was supposedly, quote, irrelevant to the subject matter of the pretrial investigation being conducted by Ukraine. Yet Ukraine was investigating allegations of crossing the Ukraine-Russian border with weapons. It's difficult to see how information about Ms. Kulugina's border crossings and illegal weapons possession would not be relevant to that crime. Far from offering Ukraine the greatest measure of assistance under Article 12, Russia offered Ukraine no assistance at all. Let me conclude by focusing on ICSFT Article 18. Article 18 is essential to achieving the Convention's purpose. Article 18 requires states parties to cooperate in the prevention of terrorism financing by taking all practicable measures to prevent and counter preparations for the offenses set forth in Article 2 of the Convention. As Professor Coe explained, Russia reads this provision as a nullity under which Russia has no obligation to do anything but have a terrorism law on paper. What Article 18 really requires is what the text says. States must take all practicable measures to prevent and counter preparations for terrorism financing. Today, you have heard extensive evidence of terrorism financing offenses. Russian persons delivered weapons, money, and other support to groups well known for committing acts covered by Articles 21A and 21B of the ICSFT. In many cases, the specific weapons Russian officials provided were immediately used to commit more terrorist acts. Russian politicians, non-governmental organizations, and private persons openly raised money and collected equipment for groups that notoriously committed terrorist acts. These were Article 2 offenses, and Russia had an obligation to take all practicable measures to stop the financing of them. Instead, Russia did nothing. Russia could have prevented terrorism financing by policing its border. As Mr. Zients mentioned earlier, Ukraine specifically asked Russia to do this. UN monitors warned of the devastating consequences to the human rights of civilians resulting from the flow of weapons across an uncontrolled border. Yet again, Russia refused to take the most obvious practicable measure of policing it. Russia also could have instructed its own officials not to send weapons and money to groups committing terrorist acts in Ukraine. That would have been simple, practicable, and capable of preventing terrorism financing. Russia refused to take that step. Russia also could have shut down the fundraising networks used to support the groups committing terrorist acts in Ukraine. This fundraising was happening in the open, through public social media channels and websites, and it was practicable for Russia to stop it. Again, Russia did nothing. Article 18 does not speak of sitting idly by, feigning an inability to assist, and hiding behind unspecified procedural or other formalities to do nothing. It speaks of taking all practicable measures to prevent and counter the commission of terrorism financing offenses. Russia chose to take no measures at all. Russia chose to do nothing, and in doing so, it violated Article 18. The preamble of the ICSFT considers, quote, that the financing of terrorism is a matter of grave concern to the international community as a whole. Today, you have heard that the financing of terrorist acts in Ukraine by Russian persons was of no concern to Russia, and Russia did nothing to fulfill its obligations under the ICSFT to investigate, to afford the greatest measure of assistance, and to take all practicable measures to counter terrorism financing. In other words, Ukraine has proven multiple violations of the ICSFT by the Russian Federation. Madam President, members of the Court, I thank you for your attention, and this concludes Ukraine's pleadings regarding the ICSFT. I would now ask that you call upon Professor Ko to speak to Ukraine's claims under the Convention for the Elimination of All Forms of Racial Discrimination.
I thank Ms. Cheek, and I now call on Professor Harold Ko to address the Court. You have the floor, Professor.
Madam President, members of the Court, it's again my honor to appear before you on behalf of Ukraine. This afternoon, I will introduce Ukraine's case concerning Russia's numerous violations of the Convention for the Elimination of All Forms of Racial Discrimination, the CERD. The origins of that treaty are well known to you. The CERD emerged in response to toxic patterns of colonialism, the Holocaust, apartheid, and racist practices that have plagued our collective history. In response, the international community developed universal human rights standards to recognize the equality of all peoples. The CERD was adopted in 1965 as the first of several universal human rights treaties elaborating upon these principles. When the General Assembly adopted the convention that year, the UN Secretary General called it a most valuable instrument to empower the United Nations to carry forward its efforts to eradicate the vestiges of racial discrimination. The treaty's text reflects the states parties' resolve to adopt all necessary measures for speedily eliminating racial discrimination in all its forms and manifestations. To that end, the CERD establishes an absolute prohibition against racial discrimination, defined as any distinction, exclusion, restriction, or preference based on race, color, descent, or national or ethnic origin, which has the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of human rights and fundamental freedoms in the political, economic, social, cultural, or any other field of public life. As this Court knows too well, this is one of the most fundamental protections in human rights law. For that reason, the total prohibition against racial discrimination contained in the CERD is both an erga omnes obligation of states and a peremptory norm of customary international law, jus cogens. Because the CERD's prohibition of racial discrimination is absolute, no derogation from it is permitted. The CERD contains no exceptions to the prohibition on racial discrimination, other human rights treaties have affirmed its non-derogable nature, and any effort to limit human rights nevertheless requires adherence to this fundamental norm of non-discrimination. The Convention's absolute guarantees require all contracting states to suppress racial discrimination in all its forms. Yet by its discriminatory treatment of the Crimean Tatar and Ukrainian communities in Crimea, Russia has utterly failed to meet its affirmative obligations under the CERD. Even worse, Russia has sought to replace the multi-ethnic community that had characterized Crimea before Russia's intervention with discriminatory Russian nationalism, described in the report of Russia's expert Sergei Markidanov as the artificial separation of Russians and Ukrainians. So through concerted cultural erasure, Russia has established a policy and practice of racial discrimination that is the exact opposite of what the CERD requires. Russia's campaign of racial discrimination grew out of its illegal military occupation and purported annexation of the Crimean Peninsula starting in February 2014. When Russia unlawfully invaded and occupied Crimea, it identified the Crimean Tatar and ethnic Ukrainian communities as obstacles to its twin aims, annexation and regional domination. From the first days of Russia's military intervention in Crimea, representatives of the Crimean Tatar and Ukrainian communities quickly mobilized to oppose Russia's actions. Even as Russia's military intervention in Crimea was underway, the Mejlis organized a rally in front of the Crimean Parliament building in Simferopol to oppose Crimea's access to the Russian Federation, accession to the Russian Federation. The members of that body invited representatives of the local Ukrainian community to join them in protest. But as demonstrators gathered in the square, gangs of young men carrying Russian flags formed against them. And as the day unfolded, the two sides sought to push each other's supporters out of the Parliament building. In the crush, 2 people died, some 70 others were injured. And this image of Ukrainian and Crimean Tatar flags opposing Russian flags explains why the Russian authorities felt the need to punish those ethnic groups as groups. From the start of the purported annexation, Russia pitted ethnic community against ethnic community. The next day, heavily armed men in uniforms without insignia seized the Crimean Parliament building and raised the Russian flag. An occupied so-called parliament then convened an extraordinary closed session and dismissed the existing government. This sham body then appointed as Prime Minister Sergei Aksyonov, the pro-Russian leader of the radical Russian Unity Party, even though his party held only 3 out of 100 seats in the Crimean Party. These Russian proxies then moved to convene a sham referendum on Russia's invasion of Crimea. As the sham referendum approached, the Russian Federation tried and failed to induce the Crimean Tatar and Ukrainian communities to support the purported annexation. Our evidence presents the testimony of Mr. Mustafa Jamilev, the first chair of the Mejlis and a pioneering figure in the Crimean Tatar community. He testifies regarding a telephone call he had directly with President Vladimir Putin on 12 March 2014, engineered by the Russians. And during that conversation, President Putin sought the Crimean Tatars community's support for union with Russia in return for unspecified favorable treatment in the future. But Mr. Zhemilev rebuffed that request and continued to insist Crimea was part of Ukraine. The Russians conveyed a similar message to Metropolitan Clement, who is in the courtroom today. He is the head of the Orthodox Church of Ukraine, which at that time was the Crimean Eparchy of the Ukrainian Orthodox Church of Kiev Patriarchate. Father Clement describes meeting with Igor Strelkov, also known as Igor Girkin, who introduced himself as an advisor on security and defense to the Council of Ministers of the Republic of Crimea. This morning from Mr. Zions, we heard about Girkin, the notorious GRU member who later became a leader of the DPR in connection with the shootdown of MH17. Girkin informed Father Clement that, quote, he would be safe and his church would be protected if he agreed to sign a document to be published in press, confirming that in Crimea everything was calm and quiet and no illegal actions were taken against Kiev Patriarchate. Father Clement declined to sign the statement because he testified it falsely suggested his support for the purported annexation in its final form. Even as Russia was vainly seeking political support from the Crimean Tatar and Ukrainian communities, pro-Russian forces were creating a hostile and intimidating environment for these same groups. The doors and gates of Crimean Tatar houses were marked with crosses, a chilling reminder of the infamous historical episode known to Crimean Tatars as the Surgun, when Soviet authorities similarly rounded up Crimean Tatars for deportation and forced their exile based on the false pretext that they had collaborated with the Nazis during World War II. And at the same time, unidentified, uniformed armed men, little green men, began appearing in Crimean Tatar settlements claiming to own Crimean Tatar properties. As you'll soon hear in more detail, Crimean Tatar and Ukrainian activists became targets of brutal disappearances, murders, and torture. An early tragic victim was Reshat Amatov, a well-known activist in Crimean Tatar, who was kidnapped by uniformed men while silently protesting in front of the Cabinet of Ministers building in Simferopol. Mr. Amatov's body, bearing signs of brutal torture, was found 2 weeks later. The Russian Federation and its agents also sought to stir up fear and hatred by the ethnic Russian majority against the Ukrainian community through a vigorous disinformation campaign, which claimed that fascists had seized power in Kyiv and intended to come to Crimea to punish ethnic Russians there. Posts appeared across social media, claiming that Crimea was under threat from Nazis, a chilling preview of a broader disinformation campaign that Russia continues today, employing it against Ukraine to support its brutal invasion based on false claims of preventing genocide. In the divisive run-up to the Sham referendum, as this outrageous campaign poster shows, the forthcoming vote was depicted as 16 March, we choose between, on the left, Ukrainian Nazis, or on the right, Russia in Crimea. Yet despite all of this intimidation, on 16 March 2014, the vast majority of the Crimean Tatar community, and reportedly nearly 500,000 ethnic Ukrainians, boycotted the Sham referendum. Yet in reporting the results, pro-Russian Crimean authorities falsely claimed that more than 90% of the voters, on a turnout of 83.1%, had voted in favor of Crimea's union with Russia. Madam President, members of the court, it is thus no mystery why the courageous Crimean Tatar and Ukrainian opposition to Russia's brutal actions would lead an authoritarian regime, intolerant of any opposition, to deliberately target these ethnic communities for discriminatory treatment. As Ukraine demonstrates in its pleadings, the Russian Federation engaged in a two-part campaign to assert its dominance in Crimea by culturally erasing the Crimean Tatar and Ukrainian communities. First, Russia forcefully brought the full weight of its authoritarian security machinery into Crimea and applied it selectively to destroy the political and human rights of the Crimean Tatar and Ukrainian communities. Second, Russia abused its position as occupying power to promote its own culture, even while suppressing every means available to the Crimean Tatar and Ukrainian communities to preserve their own identities through cultural gatherings, mass media, education, or otherwise. The aim of both kinds of Russian action was unambiguous: racial discrimination. Their illegal purpose and effect violates the CERD's absolute prohibition against racial discrimination. Yet instead of explaining how its conduct in Crimea can be reconciled with its CERD obligations, Russia's response throughout these proceedings has instead been deflection and evasion. To evade accountability for its blatant violations of the CERD, Russia has erected a paper castle of unsupported legal arguments. But on examination, these empty arguments collapse, and the illegality of its actions cannot be denied. Instead of acting to suppress racial discrimination, as the CERD requires, Russia has shown its contempt for the Convention and the fundamental rights it safeguards by its ongoing treatment of these two groups protected by the CERD in Crimea, the Crimean Tatars and ethnic Ukrainians in Crimea. Russia's obvious disdain for equality rights is further confirmed by its refusal meaningfully to engage with the CERD committee on issues related to Crimea, Sevastopol, and the ongoing armed conflict. Madam President, members of the court, as you observed in your preliminary objections judgment in this case, quote, both parties agree that Crimean Tatars and ethnic Ukrainians in Crimea constitute ethnic groups protected under CERD. The existence of these two ethnic groups is firmly rooted in objective historical fact, confirmed by how both groups now choose to self-identify. The history of the Crimean Tatar community dates back centuries. It comprises individuals who describe themselves as such, who are Muslims of the Sunni faith, and who may but do not necessarily speak or understand a Turkic language called Crimean Tatar. As Professor Magosi explains in his expert report, central to the Crimean Tatar sense of identity has been the cultivation of historical memory, including through commemoration of historical figures and events. The Crimean Tatar community vividly recalls having spent nearly half a century in exile, thousands of miles from their ancestral home, after being brutally deported to Soviet Central Asia by then Soviet dictator Joseph Stalin at the end of the Second World War. Yet tragically, Stalin's racially discriminatory decision to impose brutal collective punishment on the Crimean Tatars as a group has now been replicated today by the current Russian regime's decision to brutally target their civil and cultural rights. By comparison, the ethnic Ukrainian community in Crimea has a more recent history. It encompasses those who speak Ukrainian as their primary means of communication, those who follow Ukrainian cultural traditions, as well as Russian speakers who self-identify as Ukrainian. The evidence shows that the Russian Federation has singled out both of these communities, Crimean Tatars and ethnic Ukrainians, as distinct ethnic groups who they subject to differential and discriminatory treatment. So by its discrimination, Russia confirms that these ethnic groups exist. Ukraine's expert, Professor Fredman, has explained, quote, where identification of an ethnic group is imposed by the dominant population in order to remove rights, or where a group is identified by the dominant population in a country as ethnically different, this will be recognized. The CERD committee has also suggested that a group may be identified by the dominant population in a country as ethnically different, even if it does not regard itself as such. And international criminal tribunals, such as the Rwanda Tribunal, have similarly observed that, among other considerations, identity could be created and entrenched by an external dominant group, such as a colonial force. But despite the parties' agreement that Crimean Tatars and ethnic Ukrainians constitute protected groups under the CERD, Russia's lawyers would reduce Ukraine's definition of ethnicity to the simplistic claim that political views can define ethnicity. Russia argues that Ukraine seeks wrongly to broaden the notion of racial discrimination under the CERD by defining the Ukrainian community in Crimea as an ethnic group in light of political views or opposition. So Russia claims that Ukraine's definition of ethnicity is just a litigation tactic to further its real goal to challenge the status of Crimea. For at least 4 reasons, this court should not be sidetracked by Russia's misdirection. First, as already noted, Russia itself has admitted to the existence of a Crimean Tatar and ethnic Ukrainian community in Crimea. It has identified no specific claim or issue by Ukraine that turns on any claimed difference between the parties regarding the definition of ethnicity. Second, Russia's argument is based on a gross mischaracterization of Ukraine's position. Ukraine's claim is not that a person's ethnicity depends on political opinion. Rather, Ukraine has explained that the political community, and therefore the collectivity of other citizens with whom he or she most identifies, is a relevant factor in assigning ethnicity. It's no surprise that common ethnic identity will breed political community. History shows that ethnic groups usually desire to live together within a common political state. As Professor Magosi has explained, this has been a goal of the Ukrainian nationalist movement since the 19th century, and especially since Ukraine's independence in 1991. Identification with the Ukrainian state has become an increasingly important marker of Ukrainian self-identity. This is particularly true among younger Ukrainians who have grown up exclusively within a free and democratic Ukraine. These are the people who are fighting for Ukraine now. For many Ukrainians in Crimea, it's obvious why, especially after Russia's invasion in February 2014 and its even more brutal invasion of the entire territory of Ukraine 9 years later, that their self-identification as Ukrainians, not Russian, would only intensify. Third, Russia argues for an outdated, static view of ethnicity, relying on this court's quite different judgment in Qatar versus UAE. But as the court recalls, that case was not about ethnic origin. It concerned whether the CERD's protection based on national origin extends to measures based on national citizenship. This court was thus called upon to interpret the meaning of the term national origin as that phrase is used in the CERD. But on its face, the concept of national origin is plainly distinct from the term at issue here, ethnic origin. This distinction is also reflected in the convention's drafting history. And so the court in Qatar versus UAE considered issues that specifically concern national origin, such as the CERD's express exclusion of measures based on citizenship reflected in Articles 1.2 and 1.3, as well as evidence from the Convention's drafting history. The court held the term national origin does not encompass current nationality. But in this case, unlike the Qatar case, is about discrimination based solely on ethnic origin, directed against affected communities who are undeniably protected ethnic groups under the CERD. And fourth, Russia charges that Ukraine's definition of ethnicity demonstrates that its real goal is to challenge the status of Crimea. But this is only further evidence of Russia's effort to make this case something it is not. As this court has already acknowledged, Ukraine does not ask this court to make any determination regarding the status of Crimea. Ukraine seeks only to hold Russia accountable for its naked violations of the CERD. Russia's baseless claim simply ignores this court's own clear statement at preliminary objections that in the present case, the court notes that Ukraine is not requesting that it rule on issues concerning the Russian Federation's purported aggression or its alleged unlawful occupation of Ukrainian territory, nor is the applicant seeking a pronouncement from the court on the status of Crimea or on any violations of rules of international law other than those contained in the ICSFT and CERD. These matters, therefore, do not constitute the subject matter of the dispute before the court. It could not be any clearer. So in sum, Russia cannot hide behind its purported annexation of Crimea to evade accountability for its violations of the CERD. So the question before you is discrimination, pure and simple. Has Russia discriminated against the Crimean Tatar and ethnic Ukrainian communities in the peninsula in purpose or effect? But instead of answering that straightforward question, Russia tries to justify its discrimination, such as its ban on the Mejlis, the detentions and searches of certain individuals, and the limitations imposed on the organization of certain public rallies and protests. Russia would have you excuse that discrimination based on national security, anti-extremism, and public order. But these excuses have no traction here, for the simple reason that the CERD's absolute prohibition of racial discrimination is not subject to derogation. Russia cannot claim exemption from its non-derogable CERD obligations just because it has adopted measures ostensibly directed at national security or extremist threat or a risk to public order. Russia would treat national security, anti-extremism, and public order as self-judging exceptions to its peremptory human rights obligations that it is free to invoke retroactively and at will. Although national security is recognized in international human rights law as a legitimate aim that may, under different circumstances, justify necessary and proportionate restrictions on other non-peremptory rights, it cannot provide proper justification in respect of any intrusions into so-called underlying substantive rights. Nor does international law support countering extremism as a legitimate objective that could justify restrictions on appropriate human rights. Because national anti-extremism laws do not enjoy global acceptance, they require even closer scrutiny than counterterrorism laws. But Russia would justify its actions by citing its own domestic statutes or case laws. But it is those very Russian laws and their racially discriminatory application in Crimea that violate the CERD. Russia's anti-extremism laws in particular have granted Russian authorities arbitrary powers that they have widely abused to suppress the Crimean Tatar and ethnic communities. For that reason, those laws have been widely criticized. To take just one example, in 2017, the CERD committee identified Russia's anti-extremism law, federal law number 114FZ, as vague and broad, an issue exacerbated by Russia's amendments to its criminal code. The CERD committee expressed concern that these laws contained no precise and clear criteria on how materials may be classified as extremists. The sweeping definitions in this law, the committee observed, can be used arbitrarily to silence individuals, in particular those belonging to groups vulnerable to discrimination, such as ethnic minorities, indigenous peoples, or non-citizens. Other international organizations, including notably the Human Rights Committee of the ICCPR and the Venice Commission, have echoed the CERD Committee's concerns. The European Court of Human Rights has also dealt with many cases in which it has found Russia's application of this Russian federal law in violation of international standards. Yet Russia's rejoinder entirely fails to undermine the weight of this international authority. Shortly before Russia purported to annex Crimea, Russia amended its criminal code to criminalize, quote, public calls to carry out actions aimed at violating the territorial integrity of the Russian Federation. Upon supposedly annexing the peninsula, Russia extended to Crimea the application of both its anti-extremism statute and its amended criminal code. These amendments only exacerbated the discriminatory impact of Russian federal law. And by so doing, Professor Martin Scheinin has observed, Russia effectively made it a crime to publicly state the simple fact that Crimea is part of the internationally recognized territory of Ukraine. Consequently, based on his expert review of Russia's anti-extremism laws, Professor Scheinin, the first UN Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism, concluded that these laws, quote, should not enjoy the benefit of being treated as a neutral legal framework which is being applied in good faith to the benefit of good order. Instead, he said, these laws should be regarded as suspect because their inherent features make them into a mechanism for targeting not only dangerous and violent actions, but also any mobilization or activity of ethnic communities that could be perceived to indicate disloyalty to the central government. Thus, far from justifying Russia's discriminatory treatment of the Crimean Tatar and ethnic Ukrainian communities, Russia's extremism laws are evidence of Russia's discriminatory purpose in harshly applying its laws against those communities. Russia's anti-extremist framework and its other efforts to address anti-terrorism, national security concerns, or issues of public order are thinly disguised tools to punish those ethnic communities who refuse to declare fealty to the Russian government. So at bottom, these laws are not for the purpose of national security or anti-extremism. Russia's application of these laws in Crimea has a deliberate discriminatory purpose and a devastating discriminatory effect. Because the Russian legislation and measures at issue amount to racial discrimination, this court must conclude that the CERD is violated. Russia cannot invoke allegedly legitimate aims to justify measures that choose to discriminate based on race or ethnic origin. The convention itself makes clear, even lawful ends can never justify discriminatory means. As this afternoon proceeds, we will demonstrate how the purpose and effect of Russia's measures has been to discriminate against Crimean Tatar and ethnic Ukrainians, and further show why Russia cannot escape liability by claiming such justifications as national security. Ms. Cheek will return to the podium to explain next why, as a matter of law, a state may only assert such justifications in a narrow class of cases where it must satisfy a high evidentiary burden that Russia does not remotely meet. Then my colleague, Ms. Trevino, will document, as a matter of fact, the discriminatory purpose and effect of Russia's myriad discriminatory acts in Crimea, restricting civil and political rights and erasing cultural expression. Finally, Professor Tuvenin will close our presentation by showing how Russia's overtly discriminatory campaign in Crimea has violated your provisional measures order in this case and against your clear mandate clearly and gravely aggravated this dispute. To repeat what I said this morning, the court's recent decision in the certain Iranian assets case specified that the unclean hands doctrine is not part of customary international law or a general principle of law. The court further recognized that as a defense on the merits, the court has always treated the invocation of unclean hands with the utmost caution. Russia's exorbitant unclean hands claim here again shows why this utmost caution is warranted. Just as Russia did to advance the same argument to evade its responsibility under the ICSFT, it is making similar outlandish claims against Ukraine, baselessly branding Ukrainian and Ukrainian government as Nazis who are oppressing Russian speakers. But Russia supports its claim with no evidence because there is none. Russia simply repeats its own government propaganda, outrageously mischaracterizing both objective facts and applicable Ukrainian laws. Madam President, members of the court, Russia's efforts are particularly egregious in a case like this, where the treaty involved is a landmark, erga omnes human rights instrument, and where Russia has engaged in systematic campaign of racial discrimination that violates almost every provision of this historic treaty. Russia would distract you from its own egregious misconduct by claiming that Ukraine is mistreating ethnic minorities in its territory, including Crimean Tatars. Crimean Tatars who had been forcibly deported from Crimea under Stalin returned to an independent Ukraine, encouraged by Ukrainian authorities. Before Russia's purported annexation, Ukraine worked hard to build a genuinely multi-ethnic society of Ukrainian, Russians, and Crimean Tatars, as well as other groups in Crimea. Ukraine has acknowledged the challenges that it has faced in reintegrating hundreds of thousands of returning Crimean Tatars into the economy and society of the peninsula. But Ukraine has also demonstrated that, unlike Russia, it made conscious, substantial efforts to promote multiculturalism in Crimea. So just before the purported annexation in 2013, the High Commissioner for National Minorities of the OSCE praised the Ukrainian government for its efforts to reintegrate the Crimean Tatar and other formerly deported peoples, while noting that much work remained to be done. And these efforts continue today, as reflected in the law on indigenous peoples of Ukraine, adopted in July 2021. But crucially, this case is not about Ukraine's treatment of any of these minorities. This case challenges Russia's many acts of discrimination in violation of the CERD with respect to the Crimean, Tatar, and Ukrainian communities. For all of its rhetoric, Russia has conspicuously declined to raise any counterclaims challenging Ukraine's liability under the convention. Russia's glaring omission makes its renewed unclean hands argument not just demonstrably false, but just legally irrelevant to the case before you. Madam President, members of the court, every day we witness Russia's contempt for the human rights of the Ukrainian people. But the point is this: Russia does not just bomb and shell. It does not just tolerate and support those who terrorize the Ukrainian people. It is pursuing a long-term project to erase the rights and culture that make Ukraine a proud multi-ethnic nation, to wipe out what makes Ukrainians, Ukrainians, and what makes Crimean Tatars, Crimean Tatars. And now, Russia would seek to enlist this court to condone this blatantly discriminatory campaign. But after so many years, the path is finally clear. You can finally rule on the merits that Russia's acts violate this historic convention for the elimination of all forms of racial discrimination. The law is clear. The evidence is overwhelming. We ask you to give judgment for Ukraine and thereby to send a message to all nations by rejecting Russia's transparent attempt to avoid accountability for its discrimination in Crimea. I now ask that you call to the podium Ms. Cheek.
I thank Professor Coe, and I now give the floor again to Ms. Marnie Cheek. You have the floor, Ms. Cheek. Please go ahead.
Madam President, members of the court, it's an honor to appear again before you in these proceedings on behalf of Ukraine. The focus of my presentation will be the legal obligations of the Russian Federation under the Convention for the Elimination of All Forms of Racial Discrimination. First, I will address the definition of racial discrimination reflected in Article 1.1 of the Convention. In this context, I will clarify that Ukraine's claims are those of race discrimination, not political discrimination. I also will address Russia's mistaken argument that its forced citizenship regime is beyond the CERD's purview. Second, I will focus on Russia's legal violations of the CERD, which will then be addressed in more detail by my colleague, Ms. Clovis Trevino. Finally, I will discuss the appropriate standard of proof in this case. I will explain why this court must reject Russia's attempt to make racial discrimination under the CERD more difficult to prove, just because Russia has aggressively engaged not only in individual isolated instances of discrimination, but in a pattern of discriminatory conduct. Let me first turn to the Convention's definition of racial discrimination. As you are aware, the Convention defines racial discrimination broadly. The first element of the definition is, quote, a distinction, exclusion, restriction, or preference. The plain meaning of this language reflects the CERD's broad prohibition on all forms of racial discrimination. The drafting history of the Convention further confirms the intended breadth of this language. As noted by Finland's representative in the early stages of the Convention's drafting, quote, the words distinction, exclusion, preference, and limitation would cover all aspects of discrimination which should be taken into account. The word limitation was ultimately replaced by restriction, but this amendment does not detract from the point. By the time the Third Committee came to a vote on what would become the final text of Article 1.1, the drafter's intention was clear. In the words of the U.S. delegate, quote, every form of racial discrimination was pernicious, and the Convention's definition in Article 1 applied to every manifestation of that evil, even if each one was not specifically mentioned. The second element of the definition of race discrimination requires that the relevant distinction, exclusion, restriction, or preference be based on a protected ground, namely race, color, descent, or national or ethnic origin. It's well understood that Ukraine's claims focus on discrimination as to ethnic origin against the Crimean Tatars and the ethnic Ukrainians in Crimea. Discrimination based on a protected ground is a broad concept. As Judge Crawford explained in his declaration at the provisional measures phase of this case, Article 1, quote, does not require that the restriction in question be based expressly on racial or other grounds enumerated in the definition. It is enough that it directly implicates such a group on one or more of these grounds. The breadth of the term based on is confirmed by the context in which it appears in Article 1.1. As the CERD committee explained in its general recommendation number 14, quote, "The words based on do not bear any meaning different from on the grounds of, such that a distinction is contrary to the convention if it has either the purpose or effect of impairing particular rights and freedoms." This leads me to the third element of the Article 1.1 definition of racial discrimination, the phrase purpose or effect. The disjunctive "or" in the phrase purpose or effect makes clear that the CERD protects against both discrimination that can be demonstrated to have a discriminatory purpose, as well as effects-based discrimination, where a measure is facially neutral but gives rise to a distinction, exclusion, restriction, or preference in the form of an impermissibly disproportionate impact on a protected class. Whether discriminatory in purpose or effect, the prohibition against racial discrimination is absolute. Put another way, once racial discrimination has been established, there is no circumstance under which a derogation is allowed, as Professor Coe explained earlier. In examining what constitutes racial discrimination under the CERD, the parties have divergent views of how to meet the definition of racial discrimination in Article 1.1 and what evidence is required. Of course, in the modern era, there are few laws that simply state a racist purpose or mandate a racist effect. And so it's appropriate, indeed it's necessary, to look to circumstantial evidence to determine whether racial discrimination has occurred. First, let me speak to purpose. Discriminatory purpose may be apparent on the face of a challenged measure, but discriminatory purpose also can be ascertained from the nature or context of the measure. With regard to the Russian Federation's actions in Crimea, Russia has singled out ethnic minorities for discriminatory treatment, including through the enforcement of broad and vague laws engaging in a pattern of conduct that evidences racial animus and discriminatory purpose. As I mentioned, once discriminatory purpose is established, the definition of racial discrimination under Article 1.1 of the CERD is met. Second, let me speak to effect. The context and circumstances of a challenged measure are also relevant to the assessment of effects-based discrimination. As the CERD committee observed in LR versus Slovakia, in assessing measures which are discriminatory in fact and effect, the committee must take full account of the particular context and circumstances of the petition, as by definition, indirect discrimination can only be demonstrated circumstantially. While the Convention speaks of purpose or effect, at times the two should be read together in assessing racial discrimination. As Judge Theodore Marone has observed, quote, "The word effect may thus bring actions for which discriminatory purpose could not be established within the scope of the Convention, by allowing the inference of purpose from effect. Where a measure is by allowing the inference of purpose from effect, consequences may be probative of an actor's intent." In other words, where a measure is discriminatory in effect, this may also be evidence that discrimination was the purpose of the measure all along. The Russian Federation claims, and I quote from its rejoinder, that where, quote, "a given measure can be reasonably justified or deemed legitimate, it does not qualify as racial discrimination under the CERD." But reasonably justified is not the applicable standard. As the CERD committee has stated in its general recommendation number 14, in seeking to determine whether an action has an effect contrary to the Convention, it will look to see whether the challenged measure has an unjustifiable disparate impact on a protected group. Further, any disparate impact on the basis of a protected ground must be based on a legitimate justification when judged against the objectives and purposes of the Convention. In the context of the ICCPR, for example, the Human Rights Committee has set out a rigorous test that looks at whether the human rights intrusive measure is, among other things, necessary, has a genuine and identifiable legitimate aim, and conforms to the strict principle of proportionality, and that the expected benefit obtained towards serving a legitimate aim invoked outweighs any adverse impact on human rights. It follows that conduct resulting in a disparate impact will constitute racial discrimination unless the relevant measure is necessary, it has a legitimate aim, and is proportionate, and that the expected benefit in furtherance of the legitimate aim outweighs any adverse impact on human rights. This is an objective assessment that precludes Russia from invoking its self-judging justifications or hiding behind its national laws to racially discriminate. Clear and objective proof is required, and the standard is high. Russia has come nowhere close to satisfying this high bar for justifying effects-based discrimination. The Court also should bear in mind that the adverse impact on human rights is comprehensive in scope, covering, in the words of Article 1.1, any acts, quote, nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of human rights and fundamental freedoms in the political, economic, social, cultural, or any other field of human life. This is the comprehensive legal framework that it should inform the Court's analysis of Ukraine's claims. I turn next to the question of whether conduct that constitutes racial discrimination in purpose or effect nonetheless falls outside the scope of the Convention merely because that conduct may have been motivated by political reasons. The answer to this question is no. The Russian Federation subjected the Crimean Tatar and Ukrainian communities in Crimea to unfavorable treatment as a collective punishment for opposing Russia's unlawful occupation of Crimea. The Russian Federation twists this fact to claim that in reality, Ukraine's complaint is that Russia has cracked down on individuals based on their political opinions, which falls outside the Convention's scope. But Ukraine's claims focus on specific, racially discriminatory measures that have had the purpose or effect of restricting the human rights of ethnic Ukrainians and Crimean Tatars. Those measures fall squarely within the Convention. The fact that Russia's discriminatory measures may have been motivated in whole or in part by politics does not exempt Russia's race discrimination from the Convention. Put another way, a distinction, exclusion, restriction, or preference based on a protected class does not fall outside the definition of race discrimination simply because the perpetrator may also have had political reasons for discriminating against these ethnic minorities. This can be illustrated by an example. In 1944, expulsion and forced deportation by the Soviet Union of the Crimean Tatar people from Crimea was allegedly motivated by Stalin's accusation that the Crimean Tatars had collaborated with Germany during World War II. But as Professor Fredman explains in her expert testimony, there's no question that had the CERD been enforced in 1944, this forced deportation would have qualified as a distinction based on ethnic origin, which has the purpose or effect of nullifying and impairing the human rights of the Crimean Tatar people, regardless of motive. If Russia were correct, a state could avoid responsibility under the CERD by asserting political reasons for its actions. but a political motive exception to the anti-discrimination norm would allow the state to set the terms of its own compliance with the CERD. That cannot be reconciled with the object and purpose of the Convention, namely, to eliminate all forms of racial discrimination, whatever the claimed motive might be. I will now say a brief word about the explicit and tailored exclusions from the broad definition of racial discrimination in CERD Article 1.1 before I turn to the substantive provisions of the CERD. The Russian Federation relies on the exclusions reflected in Articles 1.2 and 1.3 to argue that Ukraine's forced citizenship claims fall outside the scope of the Convention. But Russia misstates Ukraine's case. Ukraine's case does not concern distinctions between citizens and non-citizens within the meaning of Article 1.2, and Ukraine does not challenge legal provisions concerning nationality, citizenship, or naturalization within the meaning of Article 1.3. Rather, Ukraine submits that Russia's special citizenship regime in Crimea, which Russia explains expanded its citizenship, quote, quickly and en masse, has particularly burdened the human rights of the Crimean Tatars and ethnic Ukrainian communities in Crimea. Simply put, Russia weaponized its citizenship law to advance a policy and practice of racial discrimination against the Crimean Tatar and ethnic Ukrainian communities. In any event, as the CERD Committee has recognized, Russia cannot shield its conduct from the purview of the CERD, where such conduct has the purpose or effect of discriminating against protected groups on grounds prohibited under the Convention, including in relation to nationality and citizenship rights. As Judge Iwasawa explained in his separate opinion in Qatar versus UAE, quote, if differentiation of treatment based on nationality has the purpose or effect of discrimination based on one of the prohibited grounds listed in Article 1, Paragraph 1, it is capable of constituting racial discrimination within the meaning of the Convention. The same holds true for citizenship. I respectfully refer the Court to paragraphs 456 and 473 of Ukraine's memorial and paragraphs 557 to 569 of its reply for a discussion of the harms flowing from Russia's weaponization of its citizenship regime. Russia also argues that the Court should dismiss Ukraine's claims because they are grounded in violations of international humanitarian law. But once again, Russia misstates Ukraine's case under the CERD. Ukraine's claims, including those on forced citizenship, are based solely on the discriminatory purpose or effect of various measures on the Crimean Tatar and ethnic Ukrainian communities in Crimea, and in no way require a finding that Russia is an occupying power that is violating international humanitarian law. Madam President, members of the Court, I will now turn to the second topic in my presentation, the substantive provisions of the CERD. Through its systemic campaign of racial discrimination against the Crimean Tatar and ethnic Ukrainian communities in Crimea, the Russian Federation has violated almost every substantive provision of the CERD. I will now very briefly examine the provisions relevant to Ukraine's claims, and I will take these articles out of order, addressing first Articles 2 and 5, which together set out a vast set of obligations for states parties, prohibiting racial discrimination in connection with a wide range of human rights, before returning to the remaining articles. Article 2 of the CERD sets out the Convention's fundamental obligations. As Russia does not dispute the content or scope of its obligations under Article 2, I will address it only briefly. Under Article 2, each state has undertaken to pursue all appropriate means and without delay a policy of eliminating racial discrimination in all its forms. States have further undertaken, under subparagraph A, to engage in no act or practice of racial discrimination. A state party's responsibility will thus be engaged where it has committed individual acts of racial discrimination. A state party's responsibility will also be engaged where it has undertaken a practice of racial discrimination. In other words, a series of acts that constitute a pattern of discriminatory conduct. Under subparagraph B of Article 2, states further undertake not to sponsor, defend, or support racial discrimination by any persons or organizations. This obligation is reinforced by subparagraph D, which provides that each state party shall prohibit and bring to an end racial discrimination by any persons, group, or organization. As indicated by the CERD Committee in a 1994 report to the UN General Assembly, the broad language of these provisions captures a range of non-state actors, including private militias, paramilitaries, and other organized groups ostensibly outside the state's control. The Russian Federation has blatantly and willfully disregarded its obligations under CERD Article 2. Its discriminatory pattern of conduct directed at the Crimean Tatar and Ukrainian communities, as well as each discriminatory act comprising such a practice, violates Article 2(1)(a). As you will hear in greater detail from Ms. Trevino, Russia has engaged in a broad assault on the political and civil rights of Crimean Tatars and ethnic Ukrainians in Crimea through a pattern of physical violence, arbitrary searches and detentions, and widespread fear. It has also forced Russian culture and language onto Crimea, while stripping these protected groups of their ability to preserve and transmit their native language through education and to gather in commemoration of their history and culture. To the extent that Russia has ignored and denied responsibility for any particular discriminatory act that was undertaken by non-state agents, Russia has additionally violated its Article 2(1)(b) obligation not to sponsor, defend, or support active discrimination by any persons or organizations. I turn next to Article 5 of the Convention. This article requires states in compliance with Article 2 to prohibit and to eliminate racial discrimination in all of its forms and to guarantee the right of everyone to equality before the law, notably in the enjoyment of a series of civil, political, economic, social, and cultural rights. I will pause here to address the meaning of equality before the law in this context. The principle of equality before the law is closely related to the principle of non-discrimination. As explained by the CERD Committee in its General Recommendation number 32, the principle of equality underlying the Convention's prohibition on discrimination combines formal equality before the law with equal protection of the law, where the aim to be achieved by the CERD is de facto equality in the enjoyment and exercise of human rights. Equality before the law is therefore not synonymous with equal treatment, as Russia suggests in its rejoinder. To use the words of Judge Tanaka in his seminal dissenting opinion in Southwest Africa, the principle of equality before the law means the relative equality, namely the principle to treat equally what are equal and unequally what are unequal. Article 5, of course, then goes on to enumerate numerous fundamental rights for which equality before the law must be guaranteed. And as you will hear from Ms. Trevino, the Russian Federation has violated almost every provision of Article 5 through its treatment of Crimean Tatars and ethnic Ukrainians in Crimea. By way of example, Article 5(b) requires states parties to guarantee equality before the law with respect to the right to security of person and protection by the state against violence or bodily harm, whether inflicted by government officials or by any individual group or institution. The breadth of this protection is self-evident. It contains no restricting language and instead fully guarantees the rights of protected persons or groups. Russia has violated this provision by directly engaging in and sponsoring or tolerating a pattern of violence targeting Crimean Tatars and ethnic Ukrainian activists, including enforced disappearances, abductions, murder, and torture. Article 5D provides another example. Article 5D guarantees equality before the law with respect to a variety of listed civil rights, including the right to freedom of movement and residence within the border of a state, the right to nationality, to freedom of opinion and expression, to freedom of peaceful assembly and association. This provision has been violated by Russia's repression of the Crimean Tatars and ethnic Ukrainians' expression of their cultural identity by blocking culturally significant gatherings, denying re-registrations of the ethnic group's media organizations on pretextual grounds, and harassing and silencing their journalists. Article 5E guarantees equality before the law with respect to economic, social, and cultural rights, including the right to public health, medical care, social security and social services, the right to education and training, and the right to equal participation in cultural activities. Particularly relevant in Ukraine's case, Article 5E5 guarantees equality before the law in the enjoyment of the right to education. As Ms. Trevino will explain, regardless of whether Russia's educational system treats all students alike, it discriminates, in fact, against Crimean Tatars and ethnic Ukrainians by depriving them of previously provided public schooling in their native language that is appropriate to their needs. For the sake of completeness, let me also run through Articles 4, 6, and 7 of the CERD very briefly. Under Article 4 of the Convention, parties condemn all racially discriminatory propaganda and all organizations which are based on or which attempt to justify racial superiority. Among other measures, Article 4 requires parties to prohibit organizations and also organized propaganda activities which promote and incite racial discrimination, and not to permit public authorities or public institutions to promote or incite racial discrimination. The Russian Federation has done the exact opposite of what that provision requires. Instead of taking measures to eradicate incitement of racial discrimination, Russia has deliberately inflamed racial tensions and has encouraged or tolerated racial discrimination by third parties. This was done, for example, through Russia's disinformation campaign designed to vilify Crimean Tatars and ethnic Ukrainians in Crimea. Article 6 requires parties to assure to everyone within their jurisdiction effective protection from racial discrimination, as well as effective remedies through national tribunals and other state institutions against any acts of racial discrimination. In a report to the UN General Assembly, the CERD Committee emphasized that in instances of alleged state harm, states must fully investigate and punish any responsible actors, including state actors who are alleged to have breached this commitment. Russia has violated this provision with impunity. Rather than protecting Crimean Tatars and ethnic Ukrainian communities in Crimea from racial discrimination, the so-called courts of Crimea have actively engaged in discriminatory conduct, themselves convicting Crimean Tatar leaders on trumped-up charges, banning the Mejlis, denying relief to protected Crimean Tatar cultural heritage, and jailing ethnic Ukrainians. Finally, under Article 7, parties undertake to adopt immediate and effective measures, particularly in the fields of teaching, education, culture, and information, with a view to combating prejudices which lead to racial discrimination. By its terms, this article places an affirmative obligation on states to integrate measures into their educational, cultural, and information policies that are aimed at overcoming prejudice, particularly directed at racial or ethnic minorities. Russia has directly contravened this obligation by implementing measures in the education, cultural, and media fields that inflame prejudices and racial discrimination. For example, in the field of education, Russia has introduced a Russia First educational policy while actively suppressing minority language instruction and erasing the history of Crimean Tatars and ethnic Ukrainians from the educational curriculum. In the third and final part of my presentation this afternoon, I will now address the series of legal hurdles invented by the Russian Federation that have no basis in the CERD or this court's prior judgments. First, Russia mischaracterizes Ukraine's case in an effort to narrow its scope, and in the process misconstrues the court's judgment on preliminary objections. Second, Russia attempts to raise the standard of proof in such a way that it can evade responsibility for its pervasive discriminatory conduct. And third, Russia misstates the evidentiary requirements applicable to Ukraine's claims. Turning to my first point, Russia argues in its rejoinder that Ukraine's case is limited in scope because, according to Russia, quote, Ukraine did not bring before the court a case concerning discrete incidents by which the Russian Federation allegedly violated the CERD. To this, Russia adds that Ukraine, quote, has reformulated its original claim into one of indirect discrimination. But Russia's argument is based on a mischaracterization of Ukraine's case and a misreading of this court's preliminary objections judgment. First, Ukraine has demonstrated in its written pleadings that Russia has committed numerous individual violations of the CERD, which, taken together, constitute a pattern and practice of discriminatory conduct directed against Crimean Tatars and Ukrainian ethnic communities in Crimea that are prohibited under Articles 2, 5, etc. It has always been Ukraine's position, and here I quote Ukraine's memorial, quote, Russia has implemented measure after measure, the purpose or effect of which is to generate racial discrimination, end quote. The comprehensive nature of Russia's CERD violations leads to the inevitable conclusion that Russia has engaged in a campaign of racial discrimination against these communities in Crimea. That pattern or practice of racial discrimination is a violation of the CERD, and the text supports this conclusion. Article 2(1)A speaks to both acts of racial discrimination and practice. Article 5 speaks of the elimination of racial discrimination in all of its forms. Second, Russia is wrong that the court's preliminary objections judgment has precluded any argument by Ukraine that Russia has committed multiple violations of the CERD, which viewed in the aggregate constitute a campaign of racial discrimination. As this court observed in its judgment, quote, the individual instances to which Ukraine refers in its submissions emerge as illustrations of the acts by which the Russian Federation has allegedly engaged in a campaign of racial discrimination. It follows that Ukraine does not adopt the cause of one or more of its nationals, but challenges on the basis of the CERD the alleged pattern of conduct of the Russian Federation with regard to the treatment of Crimean Tatar and Ukrainian communities in Crimea. Consistent with this court's judgment, Ukraine has alleged that a pattern of conduct and a campaign of racial discrimination violates the CERD. Ukraine has done this by referencing illustrative individual instances of acts that also constitute racial discrimination. Moving to my second point, Russia advocates for novel evidentiary standards in this case. Specifically, Russia claims that Ukraine must show that Russia's discrimination occurred in a systematic manner, that there was an intent or purpose, specifically and directly, to target these communities as such, and Ukraine's claims must be supported by fully conclusive evidence. But Russia offers no relevant support for its argument that Ukraine must demonstrate an intentional and systematic campaign of discrimination in order to succeed in its claims, relying instead on sources that have no application to the Convention or to Ukraine's case. On review of the Convention itself, one finds no support for Russia's position. Not only is Russia's argument rooted in a mischaracterization of Ukraine's claims, it is also wholly inconsistent with the CERD's plain language. As Professor Fredman has explained, quote, "The CERD does not contain language defining systematic campaigns of racial discrimination. It follows that the correct approach is to assess each of Ukraine's claims under the standards set forth in the Convention, and as necessary for the court to take a view on Ukraine's characterizations of the aggregate impact of any violations once it is ruled on the individual claims." Despite the CERD's silence on this issue, Russia creates a new set of evidentiary rules out of whole cloth. Russia argues that Ukraine must first show the existence of identical or analogous breaches of the CERD. Second, that these breaches have to be sufficiently interconnected. And third, that they are carried out in a planned and deliberate way with the aim of singling out a particular group as opposed to isolated instances or exceptions. Russia provides no support for its newly created test. The CERD explicitly recognizes that intent is not required to establish breach. As I addressed earlier, the plain text of Article 1.1's definition of racial discrimination makes clear that claims based on discriminatory purpose and discriminatory effect are both encompassed within the Convention. And the CERD Committee has confirmed that a requirement to prove discriminatory intent runs counter to the Convention's prohibition against any and all behavior that has a discriminatory effect. Aside from being wholly unsupported by the text of the Convention, Russia's position turns Ukraine's claims on their head. Ukraine need only demonstrate discriminatory purpose or discriminatory effect. And as I have just described, Ukraine's claims are rooted in Russia's pattern of individual violations of the Convention. The pattern of Russia's conduct at issue here yields discriminatory purpose, but also, at a minimum, discriminatory effect. As Professor Fredman has explained, it is sufficient that there exists a law, practice, or policy which appears neutral on its face, but which has a disparate impact. Russia appears to focus on Ukraine's language that Russia's CERD violations amount to a systemic campaign of racial discrimination, in an attempt to analogize this campaign to genocide, and argue that fully conclusive is the standard of proof that is articulated by this court in Bosnian genocide and should apply here. But as Ukraine noted in its reply, although Ukraine's allegations are undoubtedly serious in nature, they do not involve the same kinds of violations that were at issue in Bosnian genocide. The standard of proof in Bosnian genocide is simply irrelevant to Ukraine's claims of racial discrimination under the CERD. Finally, the Russian Federation claims that Ukraine must establish a differentiation in treatment in addition to an unjustifiable disparate impact. According to Russia, such differentiation in treatment must be demonstrated by comparison using statistical data. Ukraine also takes note that while the Russian Federation had 15 months to file its rejoinder in this case, they chose on the eve of this hearing to supplement the record on the issue of statistics. Ukraine will comment on this new annex in due course. But in any case, statistical data is not required to establish racial discrimination. Simply put, this is another failed attempt by Russia to avoid liability for its plainly discriminatory conduct. As already noted, an act or practice which does not explicitly provide for a difference in treatment can nonetheless violate the CERD if it results in a discriminatory effect on a protected group. Russia's continued insistence that an effect-based claim under the CERD requires an act of distinction based on a prohibited ground, in addition to showing a disparate impact, is wrong. Russia appears intent on reading effects-based discrimination out of the Convention. With regard to statistical data, while comparative statistical data may be used as a means to demonstrate racial discrimination, it is not the only way for an applicant to make such a showing. The CERD committee, for example, does not require statistical data as an evidentiary requirement to establish a discrimination claim, nor has the court ever suggested such evidence would be required. Russia's attempt to impose this additional evidentiary requirement on Ukraine is based largely on a misrepresentation of the academic writings of Ukraine's expert, Professor Friedman. Contrary to Russia's statement in its rejoinder that Professor Friedman considers statistical evidence to be indispensable, Professor Friedman simply noted the potential relevance of statistics in indirect discrimination claims. Russia conveniently omits her further statement in the same treatise that, quote, statistical focus brings with it several complex problems, including the fact that many states do not collect data, and when statistics are available, they are difficult to apply. Finally, the court observed in Corfu Channel that in situations where, as here, relevant evidence is outside the applicant state's exclusive territorial control, the state that is not in a position to produce direct proof of certain facts, quote, should be allowed a more liberal recourse to inferences of fact and circumstantial evidence. This conclusion is directly relevant in a case such as this, where the Russian Federation has not only directly impeded Ukraine's ability to collect statistical data in Crimea, but has, in the words of the CERD Committee, refused to discuss and respond to questions posed by the CERD Committee on its discriminatory conduct in Crimea. Quite simply, Russia engages in legal gymnastics in an attempt to evade responsibility for its blatant discriminatory conduct against Crimean Tatars and ethnic Ukrainians in Crimea. But Russia's approach would leave the CERD without teeth. Madam President, I would now ask that you call Ms. Clovis Trevino to the podium to speak to Russia's CERD violations in detail, unless perhaps it is time for the coffee break. Thank you.
I thank Ms. Cheek, and before I invite the next speaker to take the floor, the court will observe a coffee break of 10 minutes. The sitting is suspended. Please be seated. The sitting is resumed, and I now give the floor to Ms. Clovis Trevino. You have the floor.
Madam President, members of the court, it is a great honor to appear before you on behalf of Ukraine. Driven by a desire to punish, the Russian Federation has subjected Crimean Tatars and ethnic Ukrainians to a systematic campaign of racial discrimination, which, as you heard, violates almost every obligation Russia has undertaken under the CERD. Russia has run a two-pronged racial discrimination campaign. First, Russia has suppressed the political and civil rights of Crimean Tatars and ethnic Ukrainians, silencing them through physical violence, oppression of their political leadership, arbitrary searches and detentions, and widespread fear. Second, Russia has assaulted Crimean Tatar and Ukrainian ethnic identity, blocking their celebrations, silencing their media, degrading their cultural heritage, and erasing their language and history from the schools of their children. Russia does not dispute the most critical facts underlying Ukraine's case, but Russia would disaggregate those facts into, quote, isolated and unconnected instances, end quote, hiding behind such justifications as national security, anti-extremism, public order, all to hide flagrant racial discrimination. But Russia's efforts to justify its conduct through false labels only admits to the underlying facts. The only question that remains before your court is whether Russia's conduct had the purpose or effect of restricting the human rights and fundamental freedoms of these protected groups. The answer is conclusively yes. Madam President, Russia has subjected Crimean Tatars and ethnic Ukrainians to a widespread pattern of suppression of their political and civil rights. It has done so by subjecting them to physical violence, persecuting the Crimean Tatar leaders and banning the Mejlis, and by harassing the broader Crimean Tatar community through arbitrary searches and detentions. Russia's first tool is suppression. Russia has subjected Crimean Tatars and ethnic Ukrainians to a series of disappearances, abductions, torture, and murder, restricting in purpose and effect the right to security of person and effective remedies against racial discrimination. Many of those who have been forcibly disappeared or kidnapped remain missing, such as Irvin Ibrahimov, a prominent Crimean Tatar who was abducted in 2016 and never seen again. He was 30 at the time of his abduction by men in police uniform. Others have been found dead, such as Rishad Ametov, a well-known Crimean Tatar activist and father of 3, who was abducted in broad daylight by the so-called self-defense forces of Crimea, who forced him into a black car and drove him away. As you can see in the video footage on the screen, available at Annex 1100 of the memorial. 2 weeks later, Mr. Ametov was found dead, including, as the Russian medical examiner reports, an open, quote, an open craniocerebral injury in the form of 2 penetrating stab wounds in the left eye socket with fractures of the facial bones, base of the skull, and concussion cracking injury of the brain, end quote. He was just 39 at the time of his brutal murder. Those who survived the atrocities all tell the same story. They were forcefully kidnapped, held in undisclosed locations, and subjected to violent interrogation and torture. Russia's evidence confirms that on March 9, 2014, Andriy Shekun and Anatoly Kovalsky were captured at the Simferopol train station by men, quote, in camouflage uniforms with St. George's ribbons, end quote. This is a widely recognized pro-Russian symbol. As Mr. Shekun recounts in his witness statement, quote, for the next 11 days, Kowalski and I were detained by these men from the GRU and their associates. During this time, we were blindfolded and badly mistreated. We were repeatedly interrogated, threatened with violence, and subjected to electric shocks. I was shot on the hands and knees, end quote. Mr. Shekun was literally grounded into submission. Russia has failed to effectively investigate these atrocities. By way of example, Russia claims that it took a series of steps to investigate Mr. Ametov's brutal murder. However, key individuals involved in his abduction, including, as indicated in Russia's criminal report on the screen, quote, a commander named Oleg, end quote, 2 men who you saw forced Mr. Ametov into a black car, and, quote, an unidentified person, end quote, who was last to hold custody of Mr. Ametov, were neither identified nor investigated. The SDF members involved were found innocent, as they were, quote, acting in accordance with their powers for maintaining public order, end quote. This is outright impunity and clear evidence of Russia's choice to deny justice to the victims. Madam President, these are only illustrations of Russia's systematic pattern of violence and intimidation. But as I said, Russia disaggregates these atrocities into, quote, isolated and unconnected instances, and disclaims all responsibility. But Russia cannot escape responsibility for these acts, as they were either carried out by Russian state organs, such as the GRU, or by actors under Russian control, such as the SDF, whose conduct Russia in any event adopted as its own when it incorporated them into the military of the occupying authorities. And even if somehow Russia could escape responsibility and attribution, Russia still violated the convention by tolerating, failing to prevent, and failing to effectively investigate these atrocities. As I said, Russia is also wrong that the atrocities committed against Crimean Tatars and ethnic Ukrainians are, quote, isolated and unconnected, end quote. Data from UN bodies, human rights monitors, and NGOs confirms that Crimean Tatars and ethnic Ukrainians have been disproportionately impacted by the violence. As the Office of the United Nations High Commissioner for Human Rights reports, between the beginning of Russia's occupation of Crimea and 30 June 2018, quote, at least 42 persons were victims of enforced disappearances, end quote, out of which 36 victims, or more than 85%, were ethnic Ukrainians or Crimean Tatars. The OHCHR also reported, quote, that in none of the cases documented have the perpetrators been brought to justice, end quote. Madam President, members of the court, these are not isolated and unconnected instances. The pattern of Russia's behavior yields not just discriminatory effect, but also discriminatory purpose. The very nature of the atrocities at issue here required a deliberate purpose to harm. And when that harm has been inflicted over and over again on people of Crimean Tatar and ethnic Ukrainian ethnicity, a strong inference can be drawn that they were deliberately targeted. You can also find Russia's discriminatory purpose from the systematic pattern of violence and impunity to which Crimean Tatars and ethnic Ukrainians have been subjected, as well as in Russia's deliberate choice not to investigate and bring the perpetrators to justice. And at a minimum, there is no question that Crimean Tatars and ethnic Ukrainians have been disproportionately impacted by the violence. Russia has not only subjected Crimean Tatars to brutal violence and fear, it has applied a second tool of suppression, harassing and oppressing the community's political leadership with the purpose and effect of restricting their political rights, including the right to equal treatment before tribunals, freedom of opinion, and freedom of association and peaceful assembly. Russia does not dispute the key facts underlying this claim. It does not dispute that it exiled much of the Crimean Tatar leadership, including Mr. Rifat Shubarov, the chairman of the Mejlis, who is in this great hall of justice today as part of Ukraine's delegation. It is also undisputed that members of the Mejlis have been charged and prosecuted by the Russian authorities. In January 2015, Russia opened a criminal case against Deputy Chairman of the Mejlis, Akhtem Chigos, along with other Crimean Tatars. They were charged for their role in the February 2014 demonstrations against Russian aggression. And as Mr. Chigos describes in his witness statement, he was not allowed to attend his trial in person, but rather via a poor video connection. And he was convicted largely based on alleged testimony by, quote, secret witnesses, end quote. To state the obvious, this is the opposite of due process. Russia has also subjected prominent members of the Mejlis to terrifying searches in their homes. As Mr. Bariev describes in his witness statement, at 6:30 in the morning of 16 September 2014, quote, 4 men in camouflage and face masks barged into the apartment with automatic weapons, and they pointed at me, my wife, and 2 small children. The oldest was 4 years old, and the youngest was 6 months old. It seemed to me that they were so much looking for prohibited items as they were trying to frighten my family, and with such searches as an example, the entire Crimean Tatar people, end quote. As the court is aware, Russia's campaign of political suppression led to an outright ban of the Mejlis in 2016. You will hear from Professor Tuvenan that in defiance of the court's provisional measures order, Russia has taken no action to lift that ban. Instead of complying with international law, Russia's oppression of the Mejlis is ongoing and intensifying. Russia's concerted measures targeting the Crimean Tatar leadership in their context are an unmistakable indicator that the community itself has been singled out for the purpose of suppressing their political rights and silencing their voices. That context was set out earlier by Professor Coe, who explained that when Russia's president sought but did not obtain the support of the Mejlis for annexation, Russia exacted collective punishment. At a minimum, Russia's measures have disproportionately impacted Crimean Tatars who have been deprived of their political leadership and their ability to advocate for their rights through their central representative institution. Unable to dispute the facts underlying Ukraine's claims, Russia hides behind familiar sham justifications: national security, public order. But as a matter of law, where discriminatory purpose is established, the Convention provides no room for justifications. The prohibition against racial discrimination is absolute and non-derogable. And even if the court were to entertain Russia's sham justifications, Russia has come nowhere close to establishing that its use of anti-extremism laws against the political leadership of the Crimean Tatar people was necessary, proportionate, and in furtherance of a legitimate aim. As Professor Shining has demonstrated, far from justifying Russia's conduct, Russia's extremism laws are evidence of their discriminatory purpose. At bottom, these laws are not for the purpose of national security or anti-extremism, but tools deployed by Russia to discriminate. Russia replies that the ban on the Mejlis falls outside the scope of the CERD because the Convention does not grant minorities a right to a representative body. But again, Russia mischaracterizes Ukraine's claim which is not premised on such a right, but on the discriminatory purpose and effect of Russia's measures against Crimean Tatars. Second, Russia claims that the Mejlis is not a representative, quote, institution, end quote, within the meaning of Article 2.1 of the Convention. But this argument is simply not credible. The Mejlis is an executive body elected by the Kurultai of the Crimean Tatar people. In the words of Russia's own witness, the Kurultai is, quote, a Congress of Crimean Tatar representatives, end quote, themselves elected directly by the Crimean Tatar people at large. This is widely known, as the OHCHR observed in 2016, quote, while approximately 30 Crimean Tatar NGOs are registered in Crimea, none can be considered to have the same degree of representativeness and legitimacy as the Mejlis and Kurultai, end quote. The Mejlis' significance has been widely recognized by various UN bodies and regional organizations, which have also consistently criticized Russia's ban. Russia has employed a third tool of suppression, subjecting the wider Crimean Tatar community to a pattern of arbitrary searches and detentions in their homes and meeting places, with the purpose and effect of restricting their core civil rights, including the right to equal treatment before tribunals and effective remedies against racial discrimination. Again, the facts underlying Ukraine's case are not in dispute, but Russia, again, denies the existence of a pattern of conduct and attempts to justify its measures, again, by invoking sham labels: national security, public order. But as Ukraine has documented and international observers corroborate, the existence of a pattern of arbitrary searches and detentions, targeting and disproportionately affecting Crimean Tatars, is self-evident. By way of example, officers of Russia's Center for Countering Extremism searched the home of Ibrahim Ibrahimov in August 2014, purportedly to locate stolen goods and silver items. The homes of Aaron Ametov and Nariman Ametov were also searched in September 2014 in connection with, quote, illegal arms trafficking, end quote. But after finding no evidence of such illegal activities, the officers confiscated religious books and personal belongings, only underscoring that the searches are pretext for harassment. Russia's counter-extremism forces have also raided Crimean Tatar meeting places. Russia's own video footage at Annex 178 of Ukraine's reply confirms that in November 2017, Russian armed officers aggressively raided a cafe favored by Crimean Tatars, allegedly to arrest Ms. Vetsy Kashka, a prominent 82-year-old Crimean Tatar activist, as well as other Crimean Tatars, on an absurd allegation of extortion. Russia admits that Ms. Kashka died shortly after being detained. Russia's own evidence also shows that a group of armed and masked officers raided a cafe in Simferopol and detained and interrogated dozens for alleged participation in, quote, extremist organizations, end quote. Russia does not deny that the detainees were mostly Crimean Tatars. Again, these are part of a discriminatory pattern of conduct, not isolated and unconnected instances. As international observers confirm, as early as 2016, for example, the OHCHR expressed concern, quote, about the growing number of large-scale police actions conducted with the apparent intention to harass and intimidate Crimean Tatars, end quote. In September 2018, the OHCHR observed, quote, that Crimean Tatars were disproportionately subjected to police and FSB raids of their homes, private businesses, or meeting places, often followed by arrests, end quote. OHCHR notes not only that virtually all searches in 2017 and 2018 targeted Crimean Tatars, but also, as you saw, the raids often involved, quote, excessive use of force not warranted by the circumstances, going beyond the lawful objective of preventing crime and protecting the rights and freedoms of others, end quote. This pattern of discriminatory searches and detentions has continued. In February 2021, the Commissioner for Human Rights raised concerns at the Council of Europe, quote, about a clearly discernible pattern, end quote, of arbitrary arrests and detentions of Crimean Tatars, as well as, quote, abusive raids on their homes and mosques, criminal proceedings devoid of fair trial guarantees, and extremely severe sentences, including long prison terms, end quote. From 1 January 2017 to 30 June 2019, OHCHR recorded 186 searches, 140, or 75%, of which concerned homes, private businesses, and meeting places of Crimean Tatars, end quote. Madam President, these are not isolated and unconnected incidents. The discriminatory purpose of Russia's systematic measures is evident from the sheer number of arbitrary searches and detentions that Crimean Tatars have been subjected to, as well as the excessive and disproportionate force that Russia has deployed. Undeniably, these measures have also disproportionately harmed Crimean Tatars, whose sense of safety and belonging in their homeland has been shattered. Unable to dispute the facts, Russia again relies on its, quote, anti-extremism legislation, end quote, as a shield from racial discrimination. But because Ukraine has established discriminatory purpose of Russia's measures, the Convention leaves no room for any justification. And even if the court were to entertain Russia's so-called justification, Russia's generalized and unsubstantiated accusations of, quote, extremism, end quote, come nowhere close to meeting the strict test for showing that the challenge measures were necessary and proportionate to achieve a legitimate government aim. Taken together, the evidence before the court shows that Russia has discriminated against Crimean Tatars in both purpose and effect by restricting their exercise of civil and political human rights protected under the Convention. Such targeting on accusations of extremism also incite racial discrimination and undermines the community's sense of safety, survival, and belonging in their homeland. Madam President, as Russia advanced its campaign to silence Crimean Tatars and ethnic Ukrainians through violence and fear, it has simultaneously engaged in a second widespread campaign to assault their ethnic identity. It has done so by blocking their celebrations, silencing their media, degrading their cultural heritage, and erasing their language and children and history from the schools of their children. Let me address in particular Russia's suppression of cultural gatherings and access to education rights. Russia has suppressed the ability of Crimean Tatars and ethnic Ukrainians to commemorate events of cultural significance, restricting in purpose and effect their right to peaceful assembly and association and to equal participation in cultural activities. As you heard from Professor Coe, the cultivation of historical memory is central to the Crimean Tatar sense of identity. In particular, every May 18, Crimean Tatars commemorate the victims of the Surgum, who were forcibly deported by Stalin in 1944 and loaded onto packed cattle carts to slave labor camps far from their homeland. Similarly important for Crimean Tatars is International Human Rights Day, commemorating Crimean Tatars who were imprisoned and exiled while fighting to restore the political and collective rights of their people. For the Ukrainian community, cultural gatherings are an indispensable means of preserving their identity. Chief among them is the annual celebration of the birthday of Taras Shevchenko, a poet and writer who is considered the cultural father of Ukraine and a champion of Ukrainian independence. Madam President, members of the court, there is no dispute between the parties that, in Russia's words, quote, the decisions and measures concerning public events of which Ukraine complains were taken, end quote. For example, just 2 days before the 70th anniversary of the Surgum, Russia abruptly issued a decree prohibiting all public assemblies in Crimea until 6 June 2014, thus impeding Crimean Tatars from holding their traditional ceremony in Lenin Square. Russia blocked attempts to commemorate the most important event in the Crimean cultural calendar for 4 consecutive years. In 2014, Russia repeatedly denied permits for the Crimean Tatars community's commemoration of International Human Rights Day, invoking a number of bureaucratic excuses. First, the applicants allegedly failed to specify the estimated number of participants. Then, Lenin Square was supposedly booked through 7 January 2015. And finally, after running the clock, Russia rejected a third application as being untimely. In 2014, Russia similarly blocked planned celebrations of the 200th anniversary of the birthday of Taras Shevchenko. As described earlier, two of the event organizers, Andriy Shekun and Anatoly Kovalsky, were unlawfully detained, blindfolded, and tortured as they prepared to stage the celebration in Simferopol. Similarly, a planned celebration in Sevastopol was aggressively disrupted by violent Russian protesters. Since then, Russia's suppression of culturally significant events for these communities has continued. As the UN Office of the High Commissioner noted in a 2021 report, quote, law enforcement agencies routinely issued written warnings to potential participants of assemblies, which has had a chilling effect on the exercise of the right to freedom of assembly, end quote. The report continues, quote, Crimean Tatars were particularly affected, receiving such warnings in advance of commemorative days for Crimean Tatars, end quote. In 2020 alone, the Crimean Human Rights Group documented no fewer than 42 warnings issued to Crimean Tatars regarding the holding of peaceful rallies. No fewer than 25 police visits to Crimean Tatars, no fewer than 17 administrative fine resolutions for participation in peaceful rallies, 8 court decisions regarding fines on Crimean Tatars, and 6 resolutions ordering 5-day administrative arrests of Crimean Tatar activists. These are not, quote, isolated and unconnected incidents, end quote. The existence of a discernible pattern of conduct is evidenced not only by the sheer number of gatherings that Russia has frustrated, but also by the fact that Russia targeted the most important gatherings in the Crimean Tatar and ethnic Ukrainian cultural calendars. To recall, Russia restricted commemorations of the Surgun for 4 consecutive years. Discriminatory purpose, in turn, can be inferred not only from this pattern of conduct, but also from Russia's abusive and selective application of its legal framework on public gatherings, which permits Russian gatherings to continue unhindered while enforcing endless procedural minutiae to block events deeply meaningful to Crimean Tatars and ethnic Ukrainians. At a minimum, there is no question that Crimean Tatars and ethnic Ukrainians have been disproportionately impacted by these measures. Again, unable to dispute the facts, Russia relies on, quote, its anti-extremism legislation, end quote, as a shield for racial discrimination. But as Ms. Chik explained, whereas here, discriminatory purpose is established, the Convention provides no room for justification. And even if the court were to entertain Russia's sham labels, Russia's generalized and unsubstantiated accusations of extremism come nowhere close to meeting the strict test for showing necessity, proportionality, and a legitimate aim. The Russian Federation, for example, provides no explanation as to why Lenin Square or the alternative places proposed by the organizers were unsuitable locations to commemorate the Surgun. There are none. Finally, Russia has used its educational system as a tool of suppression to impose Russian as the dominant language of instruction and suppress the language and culture of Crimean Tatars and ethnic Ukrainians. Russia boldly proclaims that it ensures that all people living in Crimea have access to education in languages of their own choice, including in Crimean Tatar and Ukrainian. But even if this right exists on paper, it does not exist in practice. Russia has systematically suppressed Ukrainian and Crimean Tatar language education by cutting off resources previously devoted to their instruction, ending teacher training programs in these languages, pressuring parents to choose a Russian education, and harassing teachers and parents who dare to advocate for their children's education in their native language. The results are stark. The number of students receiving a Ukrainian language education decreased by more than 80% from more than 12,000 students before 2014 to just 2,154 students the first school year after occupation. In the most recent year, the number diminished to under 200 students. And of the 7 Ukrainian language schools that existed in Crimea before 2014, only 1 remained in operation as of 2023. Russia does not deny that the number of students being taught in the Ukrainian language has declined dramatically since 2014. But Russia attributes this decline to a drop in demand for education in Ukrainian. According to Russia, quote, "It was the more logical and pragmatic choice to continue education in the Russian language," end quote. But Russia has it backwards. The collapse in Ukrainian language education results not from a drop in demand, but from Russia's own policies, cutting off supply. Beyond numbers, Russia has robbed Crimean Tatars and ethnic Ukrainians not only of their ability to pass on their language, but also their history to their children. General history classes in Crimea now teach a Russian version of history. As Yulia Tishenko, who is here today as part of Ukraine's delegation, explains in her witness statement, the prejudice that currently exists in these Crimean Tatar schools can be observed in the version of history taught there. The purpose of this concept is to distort the history of Russia in support of the establishment of an idealized Russian civil identity and patriotism. One telling example is a 10th grade history textbook depicting Crimean Tatars as Nazi collaborators in World War II. To state the obvious, this textbook rehabilitates the false narrative propounded by Stalin as a basis to deport Crimean Tatars from their homeland in 1944. Taken together, the evidence before you demonstrates not only the discriminatory effect of Russia's measures, but their clear discriminatory purpose. That discriminatory purpose was made clear in June 2014, when, as quoted on the screen, the so-called Crimean Ministry of Education declared that studying the Crimean Tatar and Ukrainian languages, quote, must not be conducted at the expense of instruction and study of the official language of the Russian Federation, end quote. Russia replies that Ukraine claims entitlement to a right to education in minority languages. But that is not Ukraine's case. Russia takes issue with Ukraine's reliance on minority schools in Albania, arguing that the Permanent Court of International Justice expressly stated that equal treatment or equality in law precludes discrimination of every kind. It will not be lost on the court that Russia misreads your predecessor's advisory opinion. It is well known that the Permanent Court in that case recognized that equality in law precludes discrimination of any kind, whereas equality in fact may involve the necessity of different treatment in order to attain a result which establishes an equilibrium between different situations." End quote. Applying this principle, the Permanent Court found that the closure of private schools would destroy equality in fact, for its effect would be to deprive the Greek minority of the institutions appropriate to its needs, whereas the majority would continue to have them supplied in the institutions created by the state. This is precisely the situation here, where equal access to Russian language education discriminates in fact against Crimean Tatars and ethnic Ukrainians by depriving them of public schooling appropriate to their needs in their native language. What does this mean for affected parents and children? A letter to the editor of a Russian newspaper by Ukrainian parents captures the agony. How will the children speak, write, read in their native Ukrainian language if there are no schools, no textbooks, no teachers? This is in violation of the currently valid Article 10 of the Crimean Constitution. We have everything written on paper, but nothing in reality. End quote. Madam President, members of the court, all the evidence before you points to one conclusion. Not only has Russia failed to take any steps towards eliminating racial discrimination in Crimea, Russia has implemented measure after measure, the purpose and effect of which has been to nullify and impair the human rights of Crimean Tatars and ethnic Ukrainians. Russia has undertaken a systematic campaign of racial discrimination in Crimea since 2014 and continues to assault the past, present, and future of the Crimean Tatar and ethnic Ukrainian communities. Russia assaults their past by blocking outlets for remembrance, degrading their cultural heritage, and erasing their history from school books. It assaults their present by imposing a regime of racial discrimination and fear. And it assaults their future by robbing them of the ability to pass on their traditions, culture, and language to their children. But apparently that is not enough. Russia now threatens to erase Ukrainian identity everywhere, as Russia's president chillingly denies the existence of a separate Ukrainian people. The symmetry between past and present is tragic and unmistakable. The future is in your hands. Madam President, members of the court, this concludes my presentation. I now ask that you call Professor Tuvenan.
I thank Ms. Trevino, and I now give the floor to Professor Jean-Marc Tuvenan to address the court. You have the floor, Professor.
Je suis face à un dilemme.
Madam President, I'm facing a dilemma, a quandary. If I do as I intend to do, we will go over by some 10 minutes. Now, I know it's been a long day. I am in your hands. I can cut back and try to make things consistent nonetheless, but if you allow me to go over by some 10 minutes, I would appreciate it.
Thank you, Professor, for asking. If you think you can finish by 10 after 6, that would be fine. Please go ahead.
Thank you very much, Mr. President.
Madam President, members of the court, I stand before you once again to demonstrate that Russia has in numerous ways violated your Provisional Measures Order of the 19th of April 2017. Everyone is aware of the disdain that Russia shows for your Provisional Measures Orders, but everybody knows as well that such orders are the autonomous source of legal obligations. Defiance thereof engages the responsibility of those acting this way. Your court has seen the correspondence about the fate reserved by Russia to your order of 2017. From this, I note that Russia asserts as follows.
Issue relating to compliance with provisional measures of the court is a matter to be decided at the merits phase if the court were somehow to find that it has jurisdiction to deal with the merits and that Ukraine's application is admissible. Fin de citation.
End of quotation. In your judgment of the 8th of November 2019, your court decided that it has full jurisdiction to rule on the merits of the case. Russia considers thus, and we agree, that the time has now come for you to decide on the merits whether it infringed your order. You indicated 3 provisional measures to Russia. Refrain from maintaining or imposing limitations on the ability of the Crimean Tatar community to conserve its representative institutions, including the Mejlis, ensure the availability of education in the Ukrainian language, refrain from any action which might aggravate or extend the dispute before the court or make it more difficult to resolve. 3 obligations. None of these have been complied with. The first was indicated after the Mejlis came under a ban in 2016, which caused indignation not only on the part of Ukraine, but also within the United Nations organization. Your order of 2017 takes note of the fact that the ban on the Mejlis is a plausible violation of the Convention. It refers to the reports expressing alarm as to the ban on the Mejlis, and then decides as a provisional measure that Russia must, and I quote, the first provisional measure adopted, refrain from any action which might aggravate or extend the dispute before the court or make it more difficult to resolve concerning the community of Tatars of Crimean, and the bodies concerned include the Mejlis. Is this clear enough for everyone to understand? It would be unseemly of me not to acknowledge that sometimes your decisions are open to different interpretations, including within the court itself, but that cannot be the case here. The late Judge Crawford noted this in his statement appended to the order, and I quote, "The provisional measures ordered by the court in relation to the Mejlis requires that Russia refrain from maintaining that ban." End of quotation. In another statement, more dissenting this time, another judge indicates, and I quote, "The measure now indicated by this court under point 1 of the operative clause can be read as requiring the Russian Federation to lift or at least suspend the existing ban on the activities of the Mejlis." End of quotation. Against all expectations, Russia seeks to infer from this comment by 1 out of the 3 of 16 judges who voted against the measure that, in fact, the order did not place it under any obligation as regards the Mejlis. On the contrary, Russia says, and I quote,
"Did not to do so." Fin de citation.
End of quotation. It argues that by specifying in the chapeau of the provisional measures that the Russian Federation must act in Crimea, and I quote the court, in accordance with its obligations under the Convention, end of quotation. Your court allegedly decided that its provisional measures did not create any obligation independent of the Convention, even provisionally. For Russia, and I quote,
"Ban on the activity of the Mejlis was both legitimate and non-discriminatory, and thus fully in accordance with the Russian Federation obligations under the CERD. It follows that the court's order on professional measures was complied in this regard, in this regard." Fin de citation.
End of quotation. So that would be tantamount to you having indicated provisional measures for no purpose. In fact, your jurisprudence is constant. Your provisional measures orders are binding in character and create a legal obligation for the parties to which they are addressed. The content of such obligations might vary in precision depending on the formulation you choose. But as regards your order of the 19th of April 2017, it shows surgical precision. You order Russia to lift the ban on the Mejlis as a provisional measure, in other words, in no way ruling on the merits, a stage which has only been reached today. Russia, to this day, has not shifted from its position adopted during the provisional measures hearing, which was dismissed at that stage by 13 of 16 judges. That was in 2017. Nor does it deny this. It assumes its conduct subsequent to your order. Maître Trevino recalled before I took the floor the treatment reserved to members of the Mejlis. I will say no more. Let me just note that the Executive Council of UNESCO denounced in 2018, and I quote in French, "The brutal attacks unleashed by the Russian authorities to annihilate the Mejlis, the historic representative body of the Crimean Tatar people, to silence its leaders and members, continues without any respite in brazen defiance to the order of the International Court of Justice of the 19th of April 2017, end of quotation. That was in 2018. Ukraine alerted the court to this behaviour through correspondence on the 19th of April, 7th and 12th of June 2018, 18th of January and 19th of March 2019. In vain. Russia is unmoved. To date, Russia continues its oppression of the Mejlis, even intensifying it. There are several of its members who have been sentenced since your order, including Mr. Nariman Yalov, the senior deputy leader of the Mejlis, who was sentenced to 17 years in prison last year and who is still behind bars. This is a serious violation, fully assumed, of your order, which, I recall, draws its binding force from Article 41 of your statute. The second provisional measure was to ensure the availability of education in the Ukrainian language. Russia has not respected this obligation either. Mr. Trevino gave you the statistics as to education in the Ukrainian language. What we note is that these statistics are catastrophic. According to Russia, this is due to a lack of interest in the Ukrainian language. That is not what the inhabitants say. In its 2022 report, the United Nations Secretary General notes that, and I quote, according to Crimean Tatar graduates of schools in Crimea and parents of current students interviewed by OHCHR, the availability of instruction in Crimean, Tatar and Ukrainian and the possibility of learning those languages as subjects does not satisfy the demand. Interviewees from Simferopol, the Greater Yalta area, and Jankoy complained of the insufficient hours, low quality or unavailability of instruction in Crimean Tatar, and the lack of opportunities to enroll in Crimean Tatar language classes, end of quotation. In short, and it will come as no surprise to anyone given current developments, the policy of forced Russification of Crimea has not stopped since your 2017 order. Here again, your order has been purely and simply ignored.
And finally, since 2017, Russia has constantly aggravated or extended the dispute in all its aspects and has made its resolution more difficult. As to the part related to the Convention on the Financing of Terrorism, I would like to recall that the issue before the court is the total lack of cooperation by Russia since 2014 to prevent or suppress the financing of murderous acts committed on civilians by groups of the DPR and LPR. Both these entities are therefore indirectly accused in the present case because their actions are being scrutinized. However, Russia has decided to recognize these entities as sovereign states, and as an extension, it has pledged to provide financial and military assistance, and finally, by taking them over completely, has annexed them. I'm aware, Madam President, that the Convention does not prevent Russia from financing terrorism or conducting such activities, but that is not the point. What Ukraine claims is that the decisions taken by Russia to recognize the legitimacy of the actions of the terrorist groups in the Donbass, and specifically those of DPR and LPR, are tantamount to formally endorsing their acts retrospectively. One of the DPR's chiefs, Mr. Bushilin, who was totally involved in the acts of terror committed in Donbass, who in March 2014 enjoyed being photographed with DPR's men in 2014, when the DPR was notorious for their terrorist atrocities, Mr. Putin was lauded by the Russian government in 2022, and the media all over the world reported this. At the same time, Russia refused to suppress those who financed terrorist attacks by this group. So how could Russia possibly punish those who financed an action that it not only endorsed formally, but whose perpetrators were wholeheartedly applauded and even rewarded by Russia? Let me remind you that the application that Ukraine has defined requests the court to rule on that Russia should immediately provide full cooperation to Ukraine in all pending future requests for assistance in the investigation and interdiction of the financing of terrorism relating to legal armed groups that engage in acts of terrorism in Ukraine, including the DPR, the LPR, the Kharkiv partisans, and associated groups and individuals. End of quote. The aforementioned decisions made by Russia are a perfect example of acts making the resolution of the conflict as defined in the application more difficult. Russia has also aggravated and extended the conflict under the Convention on Racial Discrimination. First of all, it has made matters worse by amplifying discrimination against Crimean Tatars and ethnic Ukrainians, as Ms. Trevino demonstrated. Russia is targeting these groups increasingly and continuously, and in this regard, you may note that Russia imposed the conscription of Crimean Tatars disproportionately to support its aggression effort. The Committee on Racial Discrimination denounced this a few days ago.
Concerned about reports of forced mobilization and conscription, both within the territory of the state party and on other territories under its effective control, which disproportionately affect members of ethnic minorities and indigenous people. Fin de citation.
End of quote. Russia argues in its counter-memorial that military conscription is mandatory for all Russian nationals. But Russia has practically imposed Russian citizenship on the inhabitants of Crimea, thus forcing Crimeans belonging to ethnic minorities that it specifically targeted to serve massively in the army that is waging a war of aggression against their own country. The Committee for the Elimination of Racial Discrimination this month has expressed serious concerns about Russia's policies in Crimea concerning, and I quote,
numerous and serious human rights violations against members of ethnic minority groups and indigenous peoples in Crimea, in particular abductions and forced disappearance, arbitrary detentions, ill treatment, and the forcible transfer of deportation of inhabitants from those territories to the Russian Federation, and the lack of information on measures taken to investigate such allegations and to provide victims with redress and support. Destruction of and damage to Crimean Tatar cultural heritage, including tombstones, monuments and shrines, and the lack of information on investigations carried out into such allegations and on other measures to prevent such vandalism. Barriers to using and studying in the Ukrainian and Crimean Tatar languages, restrictions on the representative institutions and political rights of Crimean Tatars, such as the dissolution of the Mejlis and the prosecution and persecution of its members.
End of quote. This was this month. And there is more, because as if it was not enough to aggravate the initial conflict on racial discrimination in Crimea, Russia decided to extend its effects to the rest of Ukrainian territory that it has occupied since last year. The instigator-in-chief of this expansion is the President of the Russian Federation himself. In his professional capacity, he signed in July 2022 a program that prefigures all the actions implemented by Russia in Ukraine from February 2022 onwards. It is entitled On the Historical Unity of Russians and Ukrainians. Essentially, it denies ethnic Ukrainian identity by absorbing it completely.
Where one people, a single whole, affirme-t-il,
is what he stated to justify his policy. In reality, what he is asserting is the historical superiority of Russians over its neighbors, and therefore the subsequent obligation for Ukrainians to bow to Russian will of their own accord or forcibly. Could this be called a postmodern form of colonial racism? Before waging a colonial war, and I'm using a term used by the French president at the UN General Assembly, colonial. President Putin addressed the Ukrainian president, or rather the population of Ukraine, because he has never actually addressed the Ukrainian president himself, and he said the following:
like it or don't like it, it's your duty, my beauty.
And this pseudo-paternalistic, genuinely belittling speech was used and developed by Timothy Sergetsev, entitled What Russia Should Do with Ukraine. This article, and I urge the court to read this article in its entirety, is an incitement, contemporary incitement to hate and annihilation of a nation, its history, its culture, its language, and its aspirations. And this article opened the floodgates of racist hate speech used in Russia. And in fact, the Committee for the Elimination of Racial Discrimination was particularly alarmed.
Hatred and propagation of racist stereotypes against ethnic Ukrainians in particular on state-owned radio and television networks, as well as by public figures and government officials.
End of quote. Needless to say, Russia did nothing whatsoever to stop this. On the contrary, it is following its terrifying program obstinately. We know about the abduction of children that I will go over quickly because I don't have enough time. And to conclude, it is indeed a very somber picture that I have just presented to you. All through the day, we have developed a reality, and it is unnecessary to summarize the situation at this late hour, except to say that it is indeed a nightmarish portrait, painted conscientiously by Russia, under the organs of Stalin, and it reminds us of another very painful picture depicted by Picasso in Guernica, and neither the Convention on Terrorism Financing nor the Convention on Racial Discrimination, and not even the provisional measures that you ordered in 2017 with its usual wisdom, none of these are being respected and complied with. Madam President, thank you very much for giving me these extra few minutes, and thank you very much for your patient attention.
I thank Professor Tuvenan, whose statement brings to an end the first round of oral argument of Ukraine. The court will meet again on Thursday morning at 10 a.m. to hear the first round of oral argument of the Russian Federation. The sitting is adjourned.
Thank you.